I would like to know how much she spends on my kids. I feel like I'm kind of being punched down on here a little bit. If I'm being honest. I furnished everything monetarily, a home, provisions, groceries, food from me without her being on any kind of bill. I handled everything. My work was wanting to garnish wages from my paycheck. I said, Kristen, if they're garnishing wages, you all are living with me. We're gonna live together. I can't have them keep taking child support out of my thing. So to my knowledge, she went down to the court in Conroe and had them cancel child support, is what I was under the impression of. Cancel child support.
There is a lot that goes into every day of being a parent, obviously, and my intention has never been to bleed him dry. And I have told him that several times. I don't want to take him for everything he has.
When she rattles off the list of money that she says for school programs and stuff, again, she has a live-in partner. They live in a mansion. I don't have anybody helping me.
It's not a free ride for me.
And I take judicial notice of that, as well as the state of Texas acknowledgement of paternity regarding the child, Kristen Nicole Duvall. That's attached as Exhibit A, and also, and I see the attachment B, the agreed order in suit affecting the parent-child relationship from February 14th of 2018. It looks like the parties were joint managing conservators in that order. Ms. Duvall had the exclusive right to determine the residence of the child within Montgomery County or any county contiguous to Montgomery County, Texas. There's some travel provisions and passport provisions. Child support was set at $700 a month beginning February 1st of 2018. Mr. Sims paid that to Ms. Duvall. Health insurance, Ms. Duvall was providing it, I guess, through her job, a cost of $120 per month. Mr. Sims was ordered to pay $120 each month beginning February 1st of 2018 for cash medical payments. And there were permanent injunctions about consuming alcohol within 24 hours, transporting the child in a motor vehicle not equipped with the ignition interlock device. Okay, so I take judicial notice of that prior order, and then I also take judicial notice of Exhibit C, which is the pay record of it as of June 14th, 2023, attached to the pleading.
Your Honor, it's my understanding that the parties have agreed that Ms. Duvall will continue to cover both children under the medical support, and that cost to her is $223, and that they will continue doing the joint managing conservatorship as well as the standard possession order for the visitation. Your Honor, I would like to call Mr. Sims to the stand. Mr. Sims, can you state your name for the record?
Justin Sims.
Is what I just said to the judge correct, that y'all agree that Ms. Duvall will cover the medical support?
That she'll provide the medical support through her employer, but that she'll elect to use that insurance, but it sounds like we'll both provide it.
And is it also correct that y'all will agree to continue to doing the joint managing conservatorship and to do the standard possession order?
To my knowledge, that's correct.
Okay. Mr. Sims, are you currently employed?
Yes, ma'am.
And who's your employer?
Integrity Specialists.
And did you provide our office with a copy of your pay stubs for 2023?
Yes, ma'am.
And on those pay stubs, does it reflect that your monthly average is $13,800.63 a month?
No.
Okay. Your Honor, may I share my screen?
You may do so.
Okay, thank you. Mr. Sims, is this the pay stub that you provided to us?
Yes.
And in that year to date, does it say that you made a total of $165,607.48?
So that's a total which will include reimbursable expenses, per diem.
Yes, and I'm getting ready to ask you about those things, but on this, does it state that that's how much you made a year?
That's how much money was returned to me, which includes about 30,000 something dollars, which includes per diem, reimbursable expenses. My end, I'm showing a net that I netted $66,000,
But the gross,
$66,000.
but on
That-
your gross, does it show that this is what, according to your pay records and the pay records you provided us, it shows that your year to date is the $165,607.48. And if you
Correct.
divide that, your monthly gross is the 13,862 that I just told the judge, correct?
That part, there are caveats to that again.
Yes, and
because
I'm getting
a lot
ready
of
to
that-
go into that.
Okay. The amount on the sheet you're showing me, yes, is correct.
And for those amounts, does that include bonuses and the per diems that you were stating earlier?
Yes.
And
And reimbursable expenses. That means the money that I paid out that they had to give me back, which isn't counted toward that income.
and is
It's
it
not
also,
at all. It's just returning money that I already spent.
and is it also, did you also provide us with a letter from your employer that states, and may I share my screen again, Your Honor?
Yes.
That as of next year, that you will no longer be pertaining bonuses because you are now in a different field?
I'm not positive about next year, but as of last year and this current year, then yes, I was ineligible for bonuses last year and I'll be eligible this year. I don't know about next year.
Okay, yeah, that's what I mean, 2024. Okay, and is it your position that when we calculated our child support using the income that you gave us on your pay stubs, that you did not want us to include any of your bonuses and your per diems and anything like that?
That's correct. Money that I received last year that I netted amounted to $66,000.
And do you always receive your per diems as of last year when you went out for work?
Correct. That's to pay
And-
for lodging and meals use.
And those expenses, those reimbursed expenses, is that because you paid something out of pocket and then the company then reimbursed you?
Correct, yes.
Okay, and did you and Miss Duvall separate in September 22nd, 2023?
Sounds accurate, fairly accurate, yes.
Originally in 2018, were you ordered to pay child support of $700 and medical support of $120?
Yes, ma'am.
And real quick, let me just make that correction. It was September 22nd of 2022, correct?
Of the split?
Yes, so when you split
Yes,
up?
correct.
Okay.
Okay, I'm confused. And maybe it'll come out with the next witness. Are there any paycheck stubs that show what he's talking about? Because it's not common for reimbursable expenses to be shown as the year to date.
I'll share my screen again, Your Honor. So on his case check that he provided,
Okay, is there any way you
Uh,
can get me that so I can look at it on my own time and not just when it's being shared? I can create
Yes,
a link
ma'am.
through case. Do you know how to use Case Center? Can you
I
upload
can
it?
also afford you my whole 2023, or I haven't received 2023 yet, but 2022, I can give you a whole overall
Can I
summary that
just
includes
do,
nets and everything.
did you want me to send that to you now or do a quick recess and send it to you so you have a time to look at it?
I guess just email it to me then.
I'm emailing it right now. And may I call my next witness, Your Honor?
You may.
Ms. Duvall, can you state your name for the record?
Kristen Duvall.
You heard the agreement with the medical support and you continue to provide that through your employer. Is that still correct?
Yes, that's correct.
And that y'all agreed to keep what you already have for your, for Hope with Justin with the joint managing conservatorship and the standard possession order?
Yes.
And is it also correct that y'all separated September 22nd of 2022?
We officially separated. The relationship ended at the end of July of 2022, but I moved out of his house September 22nd of 2022.
I'm sorry, when did you officially separate and when did you move out?
We officially separated at the end of July of 2022. That's when we ended the relationship, but the kids and I remained in the home and did not move out until September 22nd of 22.
And do you know if Mr. Sims is currently employed?
Yes.
And during the time of your separation, did Mr. Sims give you any other money or items for the children other than what he was court ordered to give you in 2018?
There
Meaning
would
the
be
700
times. I'm sorry, go ahead.
Meaning the 700 he was supposed to give you for child support and the 120 he was supposed to give you in medical support?
Monetarily, no, but he did. He's bought them clothes and shoes a couple of times when they spent time at his house.
And when he would buy them clothing and shoes, is there an amount you can say that he spent on those clothing and shoes during that time?
I would have no idea.
Would you estimate like $1,000 or you're just not sure?
I don't imagine that it's $1,000. No,
Would you estimate closer to 500?
maybe 500. I guess sure 500 probably sounds about right with different pairs of shoes and clothes.
And does it cost you $223 to cover the children on your employer?
For medical and dental, yes.
No further questions, Your Honor.
Okay.
Your Honor,
Mhm.
I would like to omit the pay record, up-to-date pay record, if I may, if I could share my screen.
You may do so.
Let me make this bigger. So as of yesterday, based off of what he was currently ordered to pay in the prior order, the arrears are $520 for child support and $120 for medical support. And this is as of January 15th of this year. Your Honor, the state would ask that you appoint them joint managing conservatorship with standard visitation, that you set a medical support amount of $223, that you determine whether we should include the bonuses and per diem as far as setting child support, and you set what is reasonable for the retro. And that is it.
The state doesn't represent either of you, so I'm going to give you both a chance to speak. Mr. Sims, is there anything you'd like to say?
Absolutely. I don't know what, I mean, I'd like to refrain from trying to make this a complaint deal, but, you know, obviously some of the things I'd like known, I don't know how pertinent they are to legalities or how much it's just me wanting them considered. It's maybe a mixture of both. But again, with that number, that you showed, that 165,000 looks like a grand number again, but I only netted $66,000 last year. So when things like per diem are taken into account as an income, which it isn't an income for me, it's just to pay for lodging, meals. That's not, I mean, I know everybody pays for lodging, a home, where in my case, I work on the road most of the year. And I still have to pay for my mortgage because I have to return to a home, which I'm not reimbursed for. So the money that I pay out, you know, in hotels can be a couple $1,000s a month, sometimes more than that. Again, that's money that I pay out that I'm not reimbursed for till about 3 weeks later. So when you look at that whole number of 165, that's an accumulation of everything that was given back to me, but it doesn't reflect all of what I distributed before receiving that reimbursement. That's very important because, you know, we've had these conversations, myself and Kristen, about, well, you know, you make per diem and extra money and this and that. And I just, that shouldn't be looked at that way. I don't know. It doesn't make sense to me that a whole number like that.
Sir, we're in the middle of a hearing. Please don't interrupt. You may continue, Mr. Sims.
I'm curious, or it doesn't make much sense to me that you would take that whole number and then not account for everything that I've, you know, put out. And the year prior, there was probably a big number, same thing. I only netted $37,000 the prior year. So, and again, and I just took not a demotion, but I had to step down from a management position just because of availability and really a lot of it's just mental stress. It's hard for me to work on the road away from home most of the year, all year. My goal is to be able to leave that and to come home. It hasn't. I'm still paying a mortgage all on my own from the same home that I bought for the 4 of us, and so I'm still paying all of that. And I just want it to be considered that that big number is not the real number. That's very important to me because that number is, you know, $100,000 larger than what I made. That's a big difference.
So how will you be paid next year? Is it salary?
No, I get hourly pay, and a lot of my pay comes from an immense amount of overtime, which I'm also, you know, I'm getting older and things, and I'm not as able to work all that overtime that I've been working. My goal is to get out of that to be home. And when I do, that number is going to be even less. I make that amount because I work probably 20, 30 hours of overtime a week. You know, I almost work 2 jobs to be able to make that money. And that's not sustainable for me in the future. It's barely sustainable for me now. And to set a high bar for me keeps me in the same struggle here. I'm just one guy. I have no support, whereas she has a partner, a live-in partner. They live in a nice, big, huge house. I have no financial support. You know, I've asked her to show me records of what she spends on the kids. And the only reason I bring that up now is because that was just asked from me. You just asked her if she could show how much I spend. Well, I would like to know how much she spends on my kids. You know, it's not that I would want them to be neglected in any kind of way. I know that they're not trying to get out of anything. I've always been a provider. I always will be. I go above and beyond to be able to provide what I do for my children, above and beyond. And I just want it considered that I'm just one guy here with no team support, no parental support, no brothers and sisters, no aunts and uncles. I'm just one guy, where she's able to, you know, she has all of that. And I feel like I'm kind of being punched down on here a little bit. I'm being honest. And, you know, I'm not, and when we're talking about back child supports and back amounts and all these things, I need it to be considered that I furnished everything monetarily, a home, provisions, groceries, food, from me. Without her being on any kind of bill, I handled everything. And and I'm still having to handle it all with no help. It's just me. And, you know, now we're asking for more and more money. It's hard.
Do you have a W-2?
I will. I haven't received 2023's W-2 yet, but I can provide 2022's.
Okay, because I didn't think per diem was included in a W-2 unless it went over what was spent as reimbursement.
Well, that wasn't a W-2 that she showed. That was
No,
just
I know. And I'll admit, I don't understand a lot of what's on here. Because no, it did not get testified to.
It's confusing.
I'm trying to run some numbers, but I'm.
But other things that include reimbursable expenses are part of my management role was I would have to purchase supplies. That could be $1,000 worth of supplies that, again, comes out of my pocket until I'm reimbursed that money for those supplies. I don't necessarily like it. Other companies have company credit cards. That would be more convenient for my situation. That's just not the way the company operates at this time. So expenses as far as when I'm on the road in different states and whatever, I work on a pipeline mitigation company across the entire United States. And so depending on what state I'm in, that's where I have to buy supplies. Sometimes it's like, I don't know that I need it until that day, but we're expected to furnish that for, you know, customer compliance. And, you know, again, sometimes I'll spend couple $1,000, and then I don't get that back for 3 weeks until I get paid. And the reason I don't get paid like every 3 weeks is because we submit our time on the 1st or the 15th of the month and the very end of the month. Then it takes usually about a week for whatever reason to process all that through QuickBooks. And so I usually get paid about every 3 weeks. So, yeah. And I can furnish those receipts from things I've had to purchase and got money back for, because they don't include those receipts on those pay stubs, but I have them or can get them. So when I do my math on what I netted last year, a net of 66,000.
But so we're supposed to base this on gross income and then get to a net with certain deductions, and they're not all the same as IRS. So I can't just take your net just as much as I'm not sure I can just take this gross. I don't even know what this is year to date. I'm trying to figure out how they got that number. Ms. Arredondo, if you know and you could share that with me, that would be helpful, because I'm trying to do math as he talks and listen to everybody.
So
I'm just not getting that number, but maybe I need to count more things.
I mean, how the pay stub got the year-to-date number, or how we got our monthly income?
Even the pay stub, and maybe I just need to take a moment to read all this, because I'm not. And do you have any W-2s that show what they reported as gross?
I can check. I don't know if I can see better detailed on my pay stubs with that information than the W-2s. I can see year-to-date expenses, reimbursable expenses, all that. So in 2023, when I added up all my pay stubs, there was $29,700 in per diem. Again, that's not an income to me. I don't see how somebody can get money from me that I don't even get. My reimbursable expenses were $9,428. Again, that's not money that I received as like payment. That's money that I paid and I just got back. So I have nearly $40,000 of that is reimbursable expenses. When I do my math and I take 25% out of my net, it breaks down to, for both kids, 25% breaks down to $1,375 a month. The year prior, 25% would have been $783 a month. But I paid more than that. So if I'm due some back money, it'd be good to know that too. Because I paid for vehicles, I paid thousands of dollars for vehicles, thousands of dollars for provisions and groceries and household stuff, but I don't get any return on that. I don't get any back, retro, anything for all the things that I provided for my kids. But it sounds like I'm being expected to pay backwards stuff that is baffling to hear that I owe anything back. I know this, I want this to be.
Sir, hold on a second.
Sure.
Yeah, when I add up the pay, maybe I missed something. The adjustments, year to date, and the taxes year to date, I don't get the 166.
Your Honor,
Give me
the
one moment.
way, oh, I got the number they got.
No, I'm not getting it. I'm getting
That number is literally, if you look at the pay on the left-hand side with the payable OTTX all the way down, if you use the year-to-date all the way to the vacation hourly, that's what I got.
Oh, so that number is not even including the adjustments or the taxes withheld? Yes, okay, so it's not including, I see, so it says no gross,
Yes.
and it's not including their, so it's not including their per diem.
No,
Does Mr. Sims understand that?
that year-to-date was just the bonuses, the overtime, vacation hours. That number reaches all of that.
Okay.
I just did the math.
Okay, and I do see that that matches, okay. So maybe I'm misunderstanding. But he's saying I shouldn't include, well, he's saying I should include a lot of things. The first is bonuses based on that letter. The second is per diem, but if I'm understanding correctly now, per diem is not in that number. And then the third possibly is this questionable overtime. Is that true, Mr. Sims? Is that what your argument is?
Yes.
Okay, and do you see, if you're able to pull up the document, do you see that per diem is not included in that number?
Let me traverse from this screen here. So I'm gonna look at my 2022 W-2, or what document are you referencing mainly? So I can look at the same one.
The only one I have is your paycheck stubs.
The last pay stub that I sent?
I don't know what you sent to them, so it's hard. I can't answer that. The one that Ms. Arredondo sent to me. Can you explain, Ms. Arredondo, what you sent to me?
The last pay check, the last pay step check, yeah. The last pay check stub is what you're looking at.
The last paycheck stub I'm seeing was a net pay of $3,743.
Look at the
That
one
was
dated
paid on
December.
January 4th.
Yeah, the one dated December 15th has a breakdown of your year-to-date paid on December 20th.
So
of
31,000 of that 165 was a bonus.
I understand that.
From the previous year. $24,000 in regular time, $18,000 in overtime.
So where do you see 21,000?
24,000 in big billable regular time in Texas.
What line is that?
So in pay, just
Okay,
pay, hours, rate.
Okay, I see it.
So year to date, there's 18,000 in overtime in Texas. I'm going to calculate this at the same time. 18,684 plus holiday, I guess, regular time in Alabama, 1,944 plus regular time in Texas was 24,056. Bonus, and then the bonus also, you know, that, and that's all stuff before taxes too, you understand? So I have
We apply taxes afterwards. That's why we work off gross and get to net per the family code.
Yeah, so again, so that gross, that 165 is the gross, not the net, but I'm gonna get there. 24 bonus, 31,587, 6,584, 6,072. Okay, yeah. So that's all gross. All those year-to-date numbers are gross. So it doesn't show a number. Oh, so if you wanted to find the net, you would subtract the adjustments and the taxes from the gross right above it in summary. So you take that 165, 607, 48, subtract 46,312.71 equals 119 minus 24,972.82. So that's coming out to $94,000. $94,321. But that 94,321 is including a 2022 bonus of 31,587. So if you take that away, which I probably won't get this year, I'm not eligible for a bonus. So take 94,000 minus 31,587.48, and I get $62,734. That's what I got last year. 62,000. You know, when you work all that overtime too, it throws you in that other bracket. They almost kind of punish me for it. I make less money when I work overtime.
Ms. Duvall, is there anything you'd like to say?
He was asking for a breakdown of what I put towards the children.
I'm not sure. Actually, before we get to all that, in terms of back support, Ms. Arredondo, wouldn't they have been entitled to some possession credits when they lived together?
Yes, so when we calculated the retro based off of what he was using the income he was previously ordered to make in the 2018 order, and if you add another child to that income and times that by the 16 months, we got an amount of $2,800.
But wouldn't he have been entitled to possession credits when they were residing together and he was paying child support?
So when we did the retro, we did it from when she moved out. So from October 1st of 2022.
Is there some reason you're ignoring the time they lived together and he paid her child support?
No, when we were calculating the retro, we did it from the time that they officially moved out. And then we added the child support that he was doing of the 700. And that's how we got the 2,800.
Okay, what time frame did they live together?
We just had it when she moved out in September 22nd of 2022.
Okay, that's not my question though. Can you find out what time frame they did live together?
2020, January 2020 to the date she stated, 23.
We lived in that house together mid-March of 2020, and I moved out September 22nd, 2022.
Moved in January.
We are giving him credit for the time they were living together, which is why we calculated from the time she moved out.
How is he getting credit for the time they lived together if you're not calculating it?
And it was 2020 because she moved in right when COVID hit, and then I just spent $66,000 on the down payment on the house, and then nobody was able to work. So I had to foot the bill for the whole time we were at home, 6 months for COVID as well. But it was in January of 2020.
So doing the amount that I gave you from the October 1st of 2022 till now, we gave him the pay credit of what he paid for the child support.
But that's just for that time period.
Mm-hmm.
Weren't they living together during a period of time he paid child support?
So I didn't pay child support.
Well, hold on. I'm still trying to do calculations as we're talking. So bear with me before we get to more numbers that I'm going to have to keep track of.
Well, it won't be numbers, but the situation is I went and created an order of child support for our daughter, Hope. And I paid child support, the number that you saw that I was paying for Hope. We were able to mitigate our relationship stuff. And so she moved in and we had another child. This retro stuff, but during the time she told me, because my work was wanting to garnish wages from my paycheck. I said, Kristen, if they're garnishing wages, you all are living with me. We're gonna live together. I can't have them keep taking child support out of my thing. So to my knowledge, she went down to the court in Conroe and had them cancel child support, is what I was under the impression of. Cancel child support. Okay, so we canceled it. Now we're a unit. There is no request for child support. Nobody's taking anything out of my checks. There's no questions about that. We're functioning like a family, and we have another kid. Where this new order comes in is when she left, she said, well, now that I'm leaving, let me reopen the case. And I didn't realize that when she reopened it, they were going to say, oh, well, then you owe all that money backwards. They weren't counting for the time that they lived with me and that I was the main provider for all the provisions and home and food. But that's what happened is she went and reopened something that was already existent that, to my knowledge, I thought it just went away. I didn't know that they put it on pause and then it continues to accumulate. You know, I wasn't aware of that. I don't think either of us were, if I'm being honest.
Your Honor, he was given a possession credit. We added it to our, when you saw the pay stubs, he was given a possession credit for the time period they lived together.
Is that the
April.
43,000 or the 44,000 on your pay record?
Yes, the $44,350.90.
Okay.
And
So-
that's what zeroed it out
Okay.
during that time period.
Okay. Mr. Duvall, did you finish? So yes, okay. Now that I have a better understanding, is there anything you'd like to say?
I was just going into that I do have the children about 90% of the time. He does work away from home. He is traveling the majority of the year. So, you know, the expenses that I have with the kids, it's a cell phone for the oldest daughter so that she can be in contact with him. There's a college tuition fund that I set up for my son, myself, and that's about $220 a month starting this June. There's school lunches. There's a $900 daycare tuition a month for my son. There's the haircuts. There's the medical. There's, you know, school activities. There's growth spurts. There is a lot that goes into every day of being a parent, obviously, and my intention has never been to bleed him dry. And I have told him that several times. I don't want to take him for everything he has. I just expect a fair child support in these children that we decided to have. The relationship did not work out, but the kids are still here, and I am still raising them every single day. I don't really understand how he could get a $300,000 plus house on a $66,000 income. I don't get that whole thing. I'm not asking to take all his per diem or his bonuses. I would just like it to be fair.
Okay. Do you have a proposed number?
No, ma'am.
Okay. And sir, do you have a proposed number for child support?
The $1,300 is what I came up with as being 25%. And again, and to add to the,
One moment. Okay. So just so you're aware, sir, you got to your net and then subtracted the full bonus to get to net. I don't think that's appropriate.
I subtracted per diem reimbursable expenses.
I don't think that's the, because I see what you did. You had the gross including your bonus. Oh, net including your bonus, and then you took off the bonus to get to 62. Okay.
So does the court calculate it based on gross or net?
Gross, and then it gets to a net.
Yeah, so it's hard for me to, that's baffling to me where you would calculate money that I'm able to pay out that I never even get. A gross.
I'm not certain. The per diem is not in your gross. So I'm not calculating anything you don't get. Okay, so let me look at that letter again. It just said no bonus next year.
I was only able to provide that on a quick deal today. If it needs elaborated, I can request them. I just sent a request to send something stating that from Kimberly Gonzalez. Whenever I was speaking with her, she said, I said, this year I'm going to make less because I won't have bonus incentives. And I'm hoping to make this my last year on the road to not have to work that much overtime. It's hard for me. And I want to be here to see my kids more often. She said, well, why don't you see if they'll send you a letter? I have no idea what they're doing. They're in Minnesota, so they could be shoveling snow or frozen in. He just sent me a very quick letter just on my quick request. It wasn't anything that had much thought into it.
Honor, would you like me to share that letter again?
No, that's fine. Just give me a moment. What is your stance on overtime? You're hoping not to do it, but you're still doing the same job?
I have to right now. That's my job. I still have to pay for everything. But I work like almost 2 jobs by how much overtime I put in a month. And it's not sustainable for me. I've been doing it for 7-8 years. the way I was able to afford this home for my family is because I saved all my money and I put everything towards this home. Everything I had, drained myself. And then COVID hit, so I drained myself even more. And I can't, the longevity in this for me is dwindling away. I'm getting older. I don't want to be on the road away from home all year long, working overtime, slaving away, working 6-7 days a week. It's not sustainable for me. It was whenever I was providing for my family, and that was the drive getting me through it. Now I'm completely alone, and I want to be home, visiting my kids, living a normal life like normal people. It's not sustainable for me any longer. And because again, it's just me. When she rattles off the list of money that she says for school programs and stuff, again, she has a live-in partner. They live in a mansion. I don't have anybody helping me.
It is not a mansion, Justin, and he doesn't. We have our own bills to pay here as well. It's not a free ride for me. You are Hope and Hudson's father, and you've made that very clear to Hope several times. You have to and need to provide for your kids.
I do.
Okay, but then don't try to imply that somebody else is
Ma'am,
doing it.
ma'am, please stop with the side conversation. Senator Ardonna, could you rediscuss your request for back support? Now that I understand from a possession credit.
Yes, so
I'm sorry, you're coming in muffled.
can you hear me now?
Yes.
My signal is a little wonky. So the amount we got for the retro was $2,800. We used the income that he was previously ordered to when it was previously ordered in 2018. And we added a second child and then gave him credit for when he paid the $700. So it would be a remainder of $175 left off. Times that by the amount of 16, and we got the $2,800.
Are you asking for that plus the arrears?
Yes, ma'am. We are asking for that judgment plus the judgment on the medical support, which is $120, and the child support of $520 to be added together to make a judgment.
Did you do that number?
And as of yesterday, and that number would be, full judgment is $3,440, which is the retro of $1,800, the arrears of child support of $520, and the arrears of medical of $120 as of January 15, 2024.
Okay, I think I only have access to this is why we really have to get you on Case Center, because for complex cases, I need to go back and look at documents. Can you show the pay record again? Because I have the pay record as of June 4th,
Your Honor.
and it's odd that it's the same numbers. Okay, that's odd. Okay, so is the 3440, does that include the medical? Did I hear
Yes, so
Don't you like to take separate judgments?
yes, Your Honor.
Okay, so what judgments are you asking for?
So we would have the 2,800 plus the 520 to be together for the child support judgment in the amount of 3,320, and then a medical judgment of 120.
I thought you said 1,800 plus 520. Did I mishear you?
It was 2,800. Sorry, I didn't know if you that was the amount which was the 125 times 16 is 2,800.
Did you give him credit for anything that he paid?
So that is the credit from everything paid from the child support and medical support. Yes, ma'am. This was as of yesterday because he was paid in full in December, but not in January. He's been paying every month since that possession credit was entered in April.
I see the pay stub, pay record again.
Yes, Your Honor.
Okay. And is it just nothing's come in yet this month?
No, ma'am. Well, I think a little bit. I can give you the exact amount.
Okay, did that possession credit include any of the amounts he claims he paid towards the child since the separation?
No, ma'am.
Okay, and then my last question, you keep all saying you agree to the standard possession order, but it looks like the prior order was a modified possession order.
Yes, it was modified a little bit.
So are they changing it?
I'm not sure. I mean, quite honestly, like I said, and he said he's on the road all of the time. So it's,
Is that why it was modified?
that is why it was modified.
Okay. Ms. Arredondo, do you know if there was the intent to change it or to leave it per this prior order?
It is the attempt to keep it exactly how it is for Hope to do the same thing for Justin.
Okay, Mr. Sims, is that what you're, because you had previously said you would agree to a standard possession order on the record. Are you meaning to say you agree to what's in your prior order, or are you wanting to change it?
I had no request to change anything.
Okay. And Ms. Duvall, also just for clarity, it's going to be what's in your prior order?
Yes, that's fine.
Okay. Just wanna, before I modify something that no one wants to modify, don't want to do that. Does anyone have anything else they want to say?
I'll just add one thing, I guess, since this keeps the arrears and whatever, that gets kind of confusing to me, but if we're at a 3320 amount for arrears, I basically hear that as something that I still owe from back. Would you be in agreement to offset that, being that the 3 years that you lived with me, you claimed the kids as dependents, even though I paid all the bills? Because I didn't claim them and feel like I maybe could have, and brought it up several times and just never was agreed upon. I don't feel like I owe anything backwards at all.
All I'm asking for is from the day that we moved out of the house. I'm not asking for anything prior to that.
That's where I thought we were current. But somebody earlier told me that I was ahead $120. So all the back stuff just, it just seems like it's trying to just extract whatever out of me. I'm not getting it. Makes it seem like I'm delinquent on something, and it's kind of offensive, and I just don't think I'm delinquent on anything at all.
Okay. I'm going to make my ruling. I'm appointing you two, per your agreement, joint managing conservators, with Ms. Duvall having the right to determine the residency of the children within Montgomery County and any county that touches Montgomery County, which is the same as your prior order. I'm going to order that the visitation continue per the prior order, and not be modified for your additional child. I see that there's a request for non-disclosure in your pleading, Ms. Arredondo. I don't believe I heard any testimony about that. Is it still being pursued?
No, Your Honor.
Okay. So everyone's comfortable with their address and phone number and where they work being in the court order?
One more request. I would like for both of us to go to a co-parenting, some type of instruction, be it online or something. I think it'd be beneficial to both of us and our kids to go through some type of co-parenting, something to be able to co-manage the situation better than we have this past year.
Okay, before we get to that, did everyone, sir, I'm going to ask my question again, that no one responded to. Ms. Duvall, are you comfortable with your address and phone number and where you work being in the court order?
Yes.
Okay, and Mr. Sims, are you comfortable with your address and phone number and court order being in the order? I'm not court order, and employment information being in the court order?
Yes, ma'am.
Okay, and just to be clear, there's no outside person harassing or threatening you or, okay, and Mr. Duvall, there's no outside person, not Mr. Sims, who's threatening you or harassing you?
No.
Okay. I'm going to deny the non-disclosure request. I'm setting child support based on a gross monthly income of $8,770. I'm setting cash medical. I'm finding that Ms. Duvall provides insurance for the children, and I'm setting cash medical of $223 each month, beginning February 1st of 2024. That leaves net resources of $6,626.61. So child support for 2 children is $1,657 per month. beginning February 1st of 2024. For one child, when there's a step down, that will be $1,325. If the income drastically changes either way, this could be reviewed for a modification again. I excluded some things, but not everything. So this could very well turn out either on target or off target. I am going to find that he is in arrears as of yesterday, $520 for child support and $120 for medical support. I'm going to order back child support of $2,300, which gives a cumulative judgment as of yesterday of $2,820 against Mr. Sims. I'm ordering that he pay that back at a rate of $25 per month with a step up as children emancipate. I'm finding that Mr. Sims is in medical support arrears as of yesterday, $120, and I'm ordering that he pay that back at a rate of $5 per month beginning February 1st of 2024.
And that's only because I haven't got paid this. Okay.
Yeah, that 120 and even that 5 something is only because, yeah, the payment for January hasn't come in yet. I believe, does that cover everything?
And real quick, you said that you were doing the gross off of $8,770, correct? Okay. And can we have an entry date of January 25th, just so we have time to do the order?
Yes, yeah, and be careful with that visitation. I don't know how you
Yes.
want to do it, but just be careful with that. But yes, we can set it for entry on January 25th. If you all sign off on it ahead of time, there's no need to show up. If you want to show up just to make sure I received it, that's fine. If there's a dispute on drafting, that's what the entry date is for. So if you see the AG's draft and you think it's drafted incorrectly, and everyone has not signed off on it, show up to argue what you think, how you think it should be drafted. It's the same Zoom code. Okay. So everybody is free to go for the day. Thank you so much for coming in, and I will either see you on January 25th, and if not, good luck with everything going forward.
So I'm a little confused on those numbers. I got a $1,657 a month and a $1,325 a month. Are you adding both of those to come up with $2,900?
So that's the step down. That's when one child emancipates and you're down to just one child in this case.
I don't even really understand what that means.
Right now, there's child support being set for both of your children. And at some point, one of them will turn 18 or graduate ahead of the other one, most likely. And when that happens, those are the 2 typical reasons. You will only be paying child support for one child. They also could join the military. Someone could pass away. There's a few reasons child support stops. But generally, it's turning 18 or graduating high school.
So what are you proposing as my monthly payment now?
I am ordering that your monthly payment now is $1,657 beginning February 1st of 2024.
Plus 223 a month
Plus
on top of that?
223, yes.
And we'll get on working this order, drafting this order, Your Honor.
I'm sorry.
We're going to get on drafting this order so we can have it for the entry date.
Okay, sounds good.
Thank you.
Thank you.
Previously, Mr. Edwards has been paying $2,300 a month, correct?
Yes, sir.
So the proposed reduction, do you think you'll be able to maintain the children's needs with that amount?
Their basic needs, possibly. It would be a very big burden on myself. I'm a school teacher and I make very much less per year than he is capable of. I feel like doing this to them after their entire lives, having a lifestyle that met the lifestyle we had when we were married, would be detrimental to them and their future.
Dad retires and files for a reduction in his child support obligation.
And it's in the interest of Kieran and Cameron Edwards. The state filed a motion to adjust the child support Mr. Edwards is paying to Ms. Langley.
That's correct, Your Honor. At this time, the state will call Mr. Edwards. At the time of when the previous order was done, were you previously ordered to pay $2,300 a month in child support?
Yes, sir.
And is that for your 2 children that's before the court today?
Yes, sir.
And at that time, what kind of work were you doing when you were ordered to pay that the $2,300 a month?
I was a U.S. Border Patrol agent with Customs and Border Protection.
And have there been any changes in your job since the time of that previous order?
Yes, sir. I retired at the end of December.
And what are you making now that you are retired?
My monthly income will be, $4,459.
Is that before taxes or after taxes?
After taxes, sir.
What is your income before taxes are taken out? What's your monthly gross income?
So gross prior to insurance and everything, or just taxes?
Yes, sir. Just prior to insurance and prior to taxes.
It is $5,976.
Do you have any other minor biological children who are below the age of 18?
I do not.
Do you have health insurance available to you that is affordable?
I do.
And what would the cost be to put your children on your health insurance? And is this health insurance through your employer?
It is, yes, sir. And the cost, my total premium is $664 per month. The cost, and that covers 4 people. The cost for the children would be half of that, which is $332 per month.
$332 for health. And do you also have dental insurance?
I do, sir.
And what is the monthly cost for dental insurance for your children?
Total of $184. So half would be, I believe, $92 per month.
Are you asking the court today to modify your child support to be based on the guidelines, based on your current income that you get from your retirement?
That is correct, sir.
And do you have any other sources of income besides your current retirement income of $5,976 a month?
I do not at this time.
I have no further questions. I pass the witness.
Your witness, Mr. Elway.
Thank you, Your Honor. So your retirement was effective, was it December 31st?
December 30th.
December 30th. Okay.
Yes, sir.
And how long had you been with, I guess, the Border Patrol prior to retirement?
20 years and approximately 6 months.
Okay. So that's considered a voluntary retirement?
It is, sir. Yes.
Did the eligibility for retirement kick in at 20 years?
It did. 50, once I reached 50 years old and 20 years of service.
Okay. So are you currently 50 years old?
I am, sir.
Okay. Now you have two children that you pay support for, correct?
Correct.
Is it true currently you pay $2,300 a month?
That is correct. Yes.
Okay. And is it true the amount that that was calculated and was put into the Attorney General's paperwork was about $1,100?
Yes, I believe it was 1104 something, but near 1100. Yes, sir.
Okay. So would you agree with me? That's a little bit more than a 50% reduction.
It is a reduction. Yes, sir.
So prior to retirement was your only source of income through your employment with the Border Patrol?
Yes, it is. Yes, it was.
Okay. And that's your testimony now, is that you have no other sources of income?
That is correct.
Are you looking at taking a post-retirement job or anything like that?
I'm unsure at this point. I mean, I'm not opposed to it, but I don't know what's available or what might come available. So at this time, I am not actively in search of a job.
So, and I'll come back to that, I guess, line of question in a minute, but let me ask you this. Do you have any interest income from any sources?
No.
Do you receive any dividend income?
No.
Do you receive any royalty income?
No.
Do you receive any kind of rental income?
No.
Okay. Did you get any kind of lump sum payment upon retirement?
Yes.
And what was that?
For unused annual leave.
Okay. And how much was that payment?
Do I have to answer that question, sir?
Yes, you do.
Okay. It was approximately $25,000.
Do you receive any other retirement benefits?
No.
Okay. Do you have any other retirement accounts?
I have a 401k.
Do you draw from the 401k?
I do not.
Do you have any other pension?
I do not.
Do you have any kind of thrift savings plan?
That's my 401k is a thrift savings plan. I don't have a separate 401k.
Okay.
Sorry, I should have called it thrift savings. I didn't realize you knew the difference.
That's okay. I just wanted to verify we were talking about the same thing.
Yes, sir.
Do you receive any income from a trust?
No,
Any other type of annuity?
no,
Okay. Do you receive any kind of Social Security benefits?
no,
Are you receiving, have you received any unemployment benefits?
no.
Do you have a LinkedIn profile?
I do.
Okay. Is this your LinkedIn profile?
I believe so, yes.
Okay. And it lists you as a supervisory Border Patrol agent, retired U.S. Border Patrol.
Correct.
So would I be correct in saying that you recently updated this profile?
Recently, yes, sir.
Okay. And you list some of your skills here. Is that correct?
Correct.
Okay. Were these skills that you engaged in as a Border Patrol agent?
They were.
And can I ask you the purpose of updating the LinkedIn profile at this point in time?
Because I retired from the Border Patrol, and it appears from what I've been told that if I do choose to start looking for work, that's where people go to look. So as you can see, it's very incomplete and very basic because I really am not up to date with how LinkedIn worked. I've not had to look for a job in over 20 years.
Given your experience, what type of work would you be able to find with your experience?
I honestly don't know in the private sector how marketable my experience would be, sir. I've been a Border Patrol instructor for 15 years prior to, or 12 years prior to coming out to the area I'm in now. So that was the majority of my career.
Now, you provided a document to the Attorney General previously, correct? That talked about your retirement income?
Correct.
Okay. And that's the document you were taking your numbers from when you testified, correct?
Correct.
Okay. And you sent that document to me today. Is that
I
correct?
did. Yes, sir.
Okay. Now, on that document, your retirement document, it comes from the who did that document come from?
It comes from the retirement group for Federal Customs and Border Protection.
So
they're called RABIS, RABIS, I believe is what I've always heard them called.
Okay. And they calculate your retirement. It's a formula, but it takes your average, your highest 3 years, correct?
Correct. Highest 3 consecutive years.
Okay. And that was, am I correct in saying that was $172,277?
That is correct.
So how old are your daughters?
They are 17 and 14.
Okay. Now let's talk about Kieran, the oldest child. Is she in a dual high school college program?
She is.
Okay. So she's not graduated from high school yet, but she's actually physically attending college.
That is correct.
Okay. And that's through Lamar University, correct?
Correct.
Do you know
Texas Academy. Texas Academy at Lamar University.
Okay. Do you know what the costs associated with that are?
I do not know exactly what the costs associated are, but I know that she's paid up through the end of the semester, so she should have no more costs associated with that I know of associated with graduation.
Now, when you say paid up, are we talking about the tuition, or what does that entail?
Just from what I've spoken with her, it appears that they pay, it's works similar to like a college. It's tuition, lodging, food, all of that is similar to like a college program. I'm sure there are some costs associated with graduation, but I'm unfamiliar with those. I don't get a lot of contact with Kieran, unfortunately.
Okay. What about Cameron, the 14-year-old? She's a freshman in high school, correct?
Correct.
Are there any expenses, additional expenses, kind of outside the normal, typical cost of I guess, past the necessities of raising a teenager that you're aware of?
I guess it depends on the type of teenager. I know she's very active in club volleyball.
Okay.
Other than that, she's active in band at school, but she's active in school activities. I know that the thing she does the most outside of that is volleyball.
Okay. But are you aware of the costs associated with the club volleyball?
I am not.
Reducing the amount of child support you pay, I guess does it make logical sense that more costs are going to be passed on to Tara?
It makes logical cost that, yes, both I and Tara will have to make adjustments with the decrease in my salary, yes.
Do you receive any kind of other fringe benefits? Does anybody pay for provide you with a vehicle or anything of that sort?
No, sir.
Any housing paid for or anything like that?
No, sir.
So at this point in time, you say you're not actively looking, but you could go back to work.
It's a possibility, and if that happens, then I'll abide by the court rules, and I will let the state of Texas know that I'm earning more money.
Okay. Now you just purchased. Is it true you purchased a new home last year?
No, I purchased a new home when I moved to West Virginia 3.5 years ago.
Okay. Is that near the Potomac River?
It is.
And you own a riverfront lot there on the Potomac River?
It came with the home, yes. It's
Okay.
part of the housing development.
And you've got some some toys, boats, and you have 4 vehicles, is that correct?
It is correct. And I see what you're getting at, and I would like to respond to that.
Well, just
Okay.
right now, just answer the question that Mr. Elrod asked you. I'll give you an opportunity at some point in time, Mr. Edwards, to respond. Okay?
Thank you, sir.
You're welcome. Go ahead, Mr. Elrod.
Are you going to be able to maintain those obligations on your income of about 71,000 before taxes?
Yes, sir. I expect to be able to do that.
Okay. But you understand you've decreased the resources available to your children as well by retiring early.
I do realize that.
And that may have an effect on their needs and so forth.
I realize that a decrease in salary affects everyone involved. Yes, sir.
Okay. I will pass the witness at this time.
Your witness, Mr. Miller.
I have no further questions for Mr. Edwards at this time.
Call your next witness.
At this time, the state will call Miss Langley. Miss Langley, you heard Mr. Edwards testify that he currently has your children covered on health and dental insurance that he gets through his employer. Do you agree that your children are covered by the health and dental plans that Mr. Edwards gets from his employer?
Yes, sir.
And do you agree with the rates that he provided to the court for the cost of the monthly costs for health insurance and the monthly costs for dental insurance?
Yes, I agree.
Do you oppose reducing Mr. Edwards's monthly child support obligation?
Yes, sir.
I have no further questions. I pass the witness.
Your witness, Mr. Elrod.
Thank you, Your Honor. Previously, Mr. Edwards has been paying $2,300 a month, correct?
Yes, sir.
So the proposed reduction to $1,100 and maybe a couple dollars, do you think you'll be able to maintain the children's needs with that amount?
Their basic needs, possibly. It would be a very big burden on myself. I'm a school teacher and I make very much less per year than he is capable of.
I guess so. Let's talk about your resources. What's your job?
Mr. Elrod, I'm trying to think of what the relevancy of Mrs. Langley's income is in regards to how much child support Mr. Edwards is supposed to pay.
Your Honor, as far as just her under the additional factors that the court can consider, the respective positions of the parties to contribute to the needs of the children.
Okay.
Your Honor, if I could.
No, you can, Mr. Edwards.
I can't.
No, you can't. Do you have an objection, Mr. Edwards?
Yes, sir.
What's your objection?
My objection would be if her information is included, shouldn't her spouse's information be included as well?
Your objection is overruled, Mr. Edwards. Go ahead,
Thank you, sir.
Mr. Elrod.
And I'll make this brief, Your Honor. So you work for the school system.
Yes, sir.
What's your approximate bring home income?
Bring home $4,300 a month.
As far as the needs of the children, we already established, do you agree with Mr. Edwards' testimony that Kieran is in a joint high school college program?
Yes, sir.
Okay. So she's not physically living at home.
She comes home on the weekends.
Okay. But she'll graduate in May. Okay. And then she'll turn 18 in June.
In June.
Okay. Now, does she have any kind of scholarship or anything like that for this program?
The way the Texas Academy works is the TEA pays for their tuition. We are responsible for room, board, books, fees. So we pay roughly $10,000 a year, $5,000 a semester for her to go to this school.
Okay. So to finish out this semester, what's the cost of that?
We're on a payment plan, and the total amount is left to pay is $2,300, and it's due by April 12th.
How often have you made some other payments recently?
Yes, sir. We paid a first payment. I don't remember exactly what it wasn't as much because the scholarship kicks in first and then we do the other payment. So I think the first payment was a few hundred, $400 or $500, and then this one. But it comes out like last semester we paid $5,000, and then it's a 2-year program. So we did this last year as well. It was $10,000 last year.
But she'll graduate in May. She'll turn 18 and emancipate anyway, correct?
Right, exactly.
Okay. But I guess in the meantime, are there still some other expenses with her being out of home? Does that require her to have a vehicle and
yes, sir.
so forth?
We have a vehicle and insurance on her so she can drive back and forth every week.
Okay. Now your younger daughter, Cameron, 14 and a freshman in high school, correct?
Mm-hmm.
Okay. Mr. Edwards said she's very active in club volleyball.
Yes, sir.
Okay. How long has she been doing that?
This is her 3rd year. So since she was 12.
Okay. Is that something that's very important to her?
Yes, sir.
Okay. Are there expenses with that?
There are very, very much so.
Okay. Can you detail those expenses for me?
Okay. Her dues for volleyball are $1,800 for the fall season and $700 for the summer beach season. And then we travel to 9 tournaments, mostly in Houston, that are just one day, but there are 2 overnight out-of-state tournaments.
Okay. Mr. Edwards, is he exercising much visitation with the children?
No, sir. He has not seen the oldest daughter since July of 2021. And he saw the youngest one over the summer briefly, but he doesn't come here. He's only been here once in the last 12 years.
Okay.
Objection. I don't see what the relevance is for the questions about visitation.
Do you have a response, Mr. Elrod?
Of course, they're listed in Chapter 154.123 as additional factors the court can consider.
Your objection is overruled, Mr.
In that he doesn't exercise much visitation, does that mean the kids are with you the vast majority of the time?
99%.
Much more so than somebody who exercises, say, a standard possession schedule.
Right.
So you don't have a period of time, whether it's every other weekend or on spring break or holidays or the summer, where you're not having to pay for the kids' basic care or whatever while they're in your possession.
Right.
So ultimately that leaves more day-to-day expense for you.
Yes, sir.
Okay. Do you believe at this point in time, Mr. Edwards is underemployed given in respect to his duties to his children?
Absolutely. Since December.
Okay.
January.
Are you expecting him to stay unemployed?
I fully feel like he will find another job. he's only 50 years old and able-bodied.
Okay.
So I think government contractor jobs or consulting jobs or whatever are usually what happens after retirement from a federal agency.
Is there any other reason that you're aware of why the court should deviate from the guideline child support amount?
I feel like doing this to them after their entire lives having a lifestyle that met the lifestyle we had when we were married would be detrimental to them and their future.
And they have some additional expenses that may not occur for every child. Is that correct?
Yes, sir.
But it's stuff they've been engaged in.
Right. And
Okay.
stuff, if we were still married with our salaries, they would probably continue, they would probably have these same opportunities.
Okay. When the kids, is he responsible for 50% of the uninsured medical expense?
On paper, yes, sir.
Does he typically?
Mr. Elrod, you don't have any pleadings on file for that.
Okay.
So let's not get into stuff we don't have pleadings on file for.
Yes, Your Honor. I will pass the witness.
Your witness, Mr. McNulty.
No further questions from the state.
Mr. McNulty, do you have any additional witnesses not sworn?
I have no
Can
other
I ask-
witnesses, Your Honor.
Well, stop, Mr. Edwards. There's a process to trial.
I'm
You're
sorry, sir.
unrepresented, but I'm still treating you like a lawyer. That means you have to act like a lawyer. You wait for your turn. I'll give you your turn, okay? The state gets to go first, and then Mr. Elrod gets to go second, and then you get to go third. All right?
I'm sorry.
Mr. McNulty, do you have any other witnesses?
No other witnesses, Your Honor. The state rests.
All right, Mr. Elrod, your turn. Do you have any additional witnesses that you wish to call?
No, Your Honor, I don't.
All right. Now, Mr. Edwards, see, I'm an old school judge, Mr. Edwards, and I believe in using the rules of civil procedure the way they were intended.
I understand, sir, and I apologize
Do you have any additional, Mr. Edwards, any information you think I need to know about this case before I make a ruling?
I would just like to, am I allowed to ask Miss Langley any questions? And
You may. You may.
Thank you, sir. Would Miss Langley, let's speaking to the visitation, when we were initially divorced, how far apart did we live?
We lived 200 miles.
Okay, so a weekend visitation, et cetera, was possible.
Yes, sir.
And did that happen when we initially were divorced?
For the first year.
Okay, and what changed that visitation schedule?
I moved.
Okay, and how far away from me did you move at that time?
800 miles.
I'm sorry, it did cut out. I couldn't hear the response.
800 miles.
800 miles. So at that point, was visitation more difficult?
It was, but we still did it. We flew back and forth on a plane until Cameron turned old enough to fly by herself.
Okay,
Okay, go ahead. Sorry.
And how often per year did that happen?
We probably flew the kids back and forth 3 or 4 times, and I drove to West Texas and to New Mexico to where you live to bring them to you multiple times a year.
So you would say that it definitely decreased based on the distance.
Yes,
Okay,
but not the way it is now.
Has Kieran been given the option to visit me in the last 2 years that you said I have not seen her?
Judge, I'm going to object to the relevance, the
Oh,
point.
no, you brought this up, Mr. Elrod. He gets to ask questions to defend himself.
I have no idea because you do not communicate with me. You only communicate with my daughter. So I don't know if you've given her the option or not.
Good answer.
I know I've bought 1 plane ticket 2 times since July 21. You've seen Cameron 2 more times, and I bought 2 plane tickets.
So you and I have not communicated that I would not force her to come visit me, that I would ask her, but I would not force her to come visit me. We have not communicated that.
You did communicate that you were not going to force her, but I have no idea if you did or not. I just know your wife to buy 1 plane ticket.
How many family cars do y'all have?
We have 3.
Okay.
1 for each of us.
What is the newest vehicle in your family.
Mr. Edwards, I don't need to hear what y'all's expenses are.
Okay,
Child support in Texas is real simple.
thank you, Your Honor.
Those were
I
good
don't have any.
questions. Those were good questions, Mr. Edwards.
Thank you, sir. I
Especially about the
appreciate
visitation. Those were good questions.
I appreciate your time, sir. I don't have
No.
anything else to
Mr.
hold you
Edwards,
up.
now I want to ask you, you're unrepresented. I need to know, do you have any information that you think I need to know about this case before I make a ruling?
Just this, sir. I've always paid my obligations. I served 20 years to defend my country. I'm not trying to shortchange my children, but right now I just got paid my first payment. It was $2,400.
Right.
So I have $100 to live on, sir.
Right.
So I can't afford.
Well, no,
what?
Mr. Edwards, let's be honest about something. You don't have $100 to live on. You got 25,000 to live on, because that's what you pulled out at the end of your stuff. That's additional income. That
I want to tell you though, that I didn't pull it. That was just
you got paid that.
correct to live on 8 months before they start paying me fully, sir.
I don't know what you did with the money, Mr. Edwards, but that's income, and it should have been factored in when this was done, and it wasn't.
But it's not income. It's only one. I mean, it's a one lump sum. It will never show up again.
Mr. Edwards.
Yes, sir.
See, I'm in the business of history, not in the business of future prediction. All of the information that Mr. Elrod was able to glean and give to me, all of the information that you were able to glean and give to me is all great information. The problem is I can't guess what your income is going to be in the future. While I understand what Miss Langley says, that you are capable of going out and getting a job, and you could do that. I can't force you to do that. You had a right to retire under the terms and conditions of the federal retirement system, and you did that. That is your right. And so that was a huge decrease in your income. But you got $25,000 additional dollars when you retired. And that was not factored in, and I'm going to factor it in because it's income. At some point in time, you're going to have to declare it, and you're going to have to pay taxes on it. Okay? Because that's how it works.
Okay. Can I ask one question? I understand your point, sir. Can I ask one question?
Sure.
So when next year, when that income is no longer part of my income, do I do this process again?
You can. If it's going to reduce your child support by more than 20% or $100, you can. You can ask for another modification. And of course, Mr. Elrod and his client are going to be able to take and see, hey, did Mr. Edwards go out and get a job, or is he just still sitting at home and still just making his $6,000 a month? You know, that's their right too. Right?
Yes, Your Honor. Thank you.
Child support's going to be adjusted to $1,500 a month effective March the 1st. Father's going to be ordered to carry the health insurance in the middle.
Sir?
Yes.
That we can't be that effective January 1st when my income changed, sir?
No, I can't. I'm not allowed to do that. Law doesn't allow me to do that.
Yes, sir.
So I'm doing March the 1st because that's at least most of the month. So at least it'll go back and pick up 1 month for you. They just filed it in November, Mr. Edwards, and I got a ruling on this case in 90 days. If you think you can find a court that's faster than that, you let me know. I'm not aware of any district courts that allow you to do child support modifications at least 6 months, but Mr. Elrod will tell me if I'm incorrect.
I think you're
That's
on the
pretty
money.
fast. That's pretty efficient. That's one thing I do pride myself on, is trying to get these cases moved fast. All right. This is what's going to happen now, y'all. The state's going to adjust this child support order that they sent into the court. If it matches what I said here today, I'm going to sign it, get it back to them. They're going to make a copy of it, send it to each of you. Now, if Mr. Elrod plainly knows, and Mr. Edwards does not, any party has the right to appeal my decision. If you wish to appeal, your appeal has to be in writing. It has to be filed in the next 3 business days in the Tyler County District Clerk's office. You're also responsible for making sure you send a copy of that written appeal to all the other non-appealing parties. Now, you don't know when I'm going to sign the order. It might take a few days for that to happen. They're generally pretty efficient about getting it to me, but you don't know specifically when your start date is going to run if you wish to appeal on the 3 days. My suggestion is you get the appeal in immediately, and that way you don't have to worry about it. It's a complicated case. This is not a straightforward, easy, this is what he makes, this is what he pays kind of case. There's lots of extenuating circumstances that go along with it. So If y'all think the district judge can do a better job than I did, you are welcome to do so, and I will not be offended of that, I promise. Okay? Mr. Elrod, do you wish to review and sign the order?
Yes, Your Honor.
All right, so they'll make sure they send it to you, Mr. Elrod, to review and sign as an attorney of record in the case. Okay? All
Thank
right,
you, Judge.
everybody should get a copy here shortly, though. They're, like I say, they're pretty good about getting them to me pretty fast. I appreciate y'all. Y'all did a wonderful job. You did a wonderful job, Mr. Edwards, of presenting your case and to give me the facts that you have for them. So, and I do appreciate y'all's patience, and I appreciate that y'all giving each other time to get the information out that you think I needed to hear.
So he doesn't owe me child support?
Not after May 21st, not after May of 2021, he doesn't. Whatever he owed
I
you.
still have Matthew.
Well, that's what I'm saying. The court order, the way this court order is written, he's not ordered to pay you child support for that child.
Really to maintain the lifestyle that I was able to provide for the kids prior to the divorce, I'm no longer able to provide. I mean, they don't have the same lifestyle with me that we've always had, and it just gets hard sometimes. Like, I can't afford that anymore.
Do you agree to pay guideline child support based on your current income to Ms. Willis?
No, because
Why not? So the final decree of divorce signed on January 6, 2021.
Yeah, the court takes just notice of that final decree of divorce, again, signed January 6, 2021.
Right. Ms. Willis, does that final decree of divorce order Mr. Mulligan to pay you any child support?
No.
Okay. Does it order Mr. Mulligan to do something else in lieu of paying child
Yes.
support?
Yes, to pay $600 of daycare and school supplies.
Okay. Since the signing of that divorce decree, has Mulligan done that?
He has done that, yes. There was a year that they were not in daycare because I was staying at home. So at that time, no, but while they have been in daycare and at the start of school, he has paid that.
Where were the children currently insured?
Through Dad, through Justin.
If Mr. Mulligan is still paying the daycare as per the divorce decree, why do you now want him paid to court?
Really to maintain the lifestyle that I was able to provide for the kids prior to the divorce, I'm no longer able to provide. I mean, they don't have the same lifestyle with me that we've always had, and it just gets hard sometimes.
Can you give an example of that?
I mean, doing extra things, or even, doing any extra things like going to a local farm here where you can pick strawberries and such. Like, I can't afford that anymore. So, I mean, I'm just unable to provide those type of things for them. So, I mean, they're not going to have the memories with me doing those type of things.
Does Mr. Mulligan provide any other support for the children at daycare cost and school supplies?
Yes, he does.
What does he provide?
He has paid for Jace's sports, and I mean, school clothes, school shoes, Halloween costumes. I mean, that type of thing. Yeah.
Passed a witness, Your Honor.
Okay, Mr. Mulligan, do you have any direct relevant questions of Ms. Willis?
no.
Okay. I can go ahead and call you. Okay, go ahead and call your next witness, Ms. Liskowski.
Okay, the state calls Mr. Mulligan. Mr. Mulligan, are you currently employed?
Yes, ma'am.
Okay, how much do you earn?
Roughly, without overtime, like $2,300 every 2 weeks.
Okay, are you paid hourly?
Yes, ma'am.
How much are you paid per hour?
37.
Okay. How many hours a week do you work?
I work shift work, so every 2 weeks it's 84 hours.
Okay. You ever work any,
Yes, I do work overtime occasionally.
about how many hours of overtime do you work per month?
I'd say maybe 30, 40 hours.
Is that your only source of income?
Yes, ma'am.
Does your employer offer health and dental insurance for you to put the children on?
Yes, they're on it.
Okay. How much does that cost you per pay period?
I think it's like 160. Well, I think it's like 160 a month.
Does your employer offer dental insurance to put the children on?
Yes.
Okay. How much does that cost you per pay period?
I'm not sure. That was both of them together. I'm sorry. I misunderstood you. That amount I told you.
Okay. Do you have any other children under the age of 18 besides Jason, Kylie?
Yes, I have 2 of them.
Okay. Do they live in the house or in your home?
Yes, ma'am.
Okay. Do you pay for Jason, Kylie's daycare every month?
I don't pay the full amount because before it was both of them going in there, I pay 2/3, which is $400 a month.
Why has it decreased?
Because it's only Kylie that's in there. When we first got divorced, it was $900 a month, so I was paying $600 a month. So now it's what's $600 a month, so I pay $400.
Is that because Jason's in school now?
Yes.
Do you provide any other support for the children on a monthly basis?
Well, I mean, everything she just listed, and then I do all the fundraisers. I do the school pictures. I do all the Halloween stuff. I do the sports. I do the dentist appointments, doctor's appointments. I pay for all that, and I give her money at Christmas time so she can get the presents she wants for them.
You have a ballpark figure on about how much you spend for the children every month?
No, I mean, I have no idea. I'd have to sit there and I'd have to look at my bank statements. But I mean, $300 maybe, I don't know, 200, 300.
Do you agree to pay guideline child support based on your current income to Ms. Willis?
No, because
Why not?
I also have them half the time. I have them half the month. So it's exactly 50-50. And I do all the extra.
When you say you could have the children 50-50, how many nights out of the week are they at your place?
They're out of the whole month, 14 days out of the month.
Pass the witness, Your Honor.
Ms. Willis, do you have any direct relevant questions of this witness?
No.
Okay. Do you work, Ms. Willis?
Yes, I do.
Okay, where do you work?
I work at a pediatric office as a nurse.
As a nurse, how much do you earn there?
I make $23.94 an hour.
How many hours a week do you work?
40.
Okay. Is it accurate? I mean, does Mr. Mulligan have the children 14 days out of the month?
Yes, he gets them on his days off.
Okay. How old is the youngest?
3.
And Mr. Mulligan, I mean, is it kind of like your position that you're just opposed to modifying it at all? Or just not to the guideline support amount, or?
No, I don't feel like I should have to modify it all. I mean, I'm a dad. I'm there for my, I can understand if I only had them every other weekend, but I have them every single day I'm off. And I do all the extra stuff that costs money. I don't ask her to do it, I do it.
And Ms. Willis, you said that he's consistently done what y'all had agreed to kind of outside of child support in that divorce decree?
Yes. I mean, he is a good dad. You know, he has done all of that.
Okay.
Sorry.
That's fine. How long have you been at this job, Mr. Mulligan?
I've been 11 years.
Okay. How long have you been working at your job, Ms. Willis?
5 years with, I just started back. I took a year off, and this is my 2nd month back.
So were you working at it at the time you got divorced in January of 2021?
Yes.
Okay. Anything further from the state, Ms. Laskowski?
No, Your Honor.
Okay. Anything further you think I need to know, Ms. Willis?
No.
Anything further you think I need to know, Mr. Mulligan?
No, sir.
Okay. Okay. And I'll just say, to modify child support, I need to find a material and substantial change from the circumstances from the date of the last order. I'm just going to say I'm having a hard time finding that here. If you guys chose not to go a specific child support amount to do this outside agreement, which is being followed, you were both, I guess, kind of likewise similarly employed at the time of the divorce. So there hasn't been any great changes, you know, from an income status for either one of you. So that being said, I think I'm just going to deny the modification altogether, leave the terms as they were per the divorce. Again, I'm just trying to explain to y'all where I'm at. I mean, it would be one thing, and I appreciate the fact that everyone's been following it. And you guys have been able to work together to the extent that you have. I mean, that's absolutely great. But you know, frankly, because of that, there hasn't been any change. It's not like Mr. Mulligan wasn't doing what he was supposed to be doing.
Right.
So I'm going to deny the modification again. So those prior terms, that's not to say that it can't get modified again in the future, because you know, it looks like at some point here daycare costs might be going down to 0 or something like that. I guess whenever the youngest gets into school, that's why I was asking what age or something we were at there. But that's going to be my ruling here today. I can't, like I say, I can't find the material and substantial change. Everyone has 3 days to request de novo appeal hearing in the district court if you don't agree with my ruling. But thank you all very much.
Previously, Mr. Edwards has been paying $2,300 a month, correct?
Yes, sir.
So the proposed reduction, do you think you'll be able to maintain the children's needs with that amount?
Their basic needs, possibly. It would be a very big burden on myself. I'm a school teacher and I make very much less per year than he is capable of. I feel like doing this to them after their entire lives, having a lifestyle that met the lifestyle we had when we were married, would be detrimental to them and their future.
Mr. Rivetto is wanting to terminate his rights.
I was considering it at the moment. I was having a bit of a panic attack because this number, it's devastating, to be honest.
Super mod that was filed in February. I got 2 children that are well under the age of 18, so that's not going to be a problem. This matters before the court on a super modification of child support and motion to confirm arrears. This was filed with Bell County back on the 7th day of February 2024.
Your Honor, both parties are present. This was an order that was done back in 2016. The state is seeking to modify it to have guideline support, which was calculated to be $966 in this case. I believe Ms. Larson is in agreement with providing medical and dental insurance through her work and being reimbursed at $314 for medical and $69 for dental. This time the case is in future pay, so we'd ask that $206.52 that Mr. Rivetto's paid ahead to be applied to any future obligation. And I believe Mr. Rivetto is wanting to terminate his rights.
Okay, I'll let Mr. Rivetto tell me those in his own words, but Mr. Rivetto, here's the deal.
If I may, Your Honor.
I'll let you make an opening, sir. What are you asking the court to do here today?
So I was considering it at the moment. I was having a bit of a panic attack because this number is it's devastating, to be honest, sir.
Okay. All right. Well, here's the deal, sir. What are you asking me to do? Are you asking me for a continuance where you go talk to a lawyer? Or you have, because right now there are no other pleadings on file other than the states requesting the modification to bring this up to guideline of what the law says you're supposed to pay under child support. I'll let you know up front, sir, there's no way that you're going to get a termination on this case. Termination requires the court to appoint a lawyer to represent the children, and you'd have to convince the children's lawyer that they're his or her client shouldn't get the money that they're entitled to under Texas law. That's never going to happen. A lawyer would get bummed out and get kicked out the bar for doing that. But again, you have the absolute right to ask for anything you want in conforming with the law, sir. And you have the absolute right. Since this matter's only been on file a few months, I'll let you go talk to a lawyer if you want. But again, you may have heard the morning speech. Guideline, and for me to do something different than that, I got to have a legal reason, sir. And that usually requires a lawyer or somebody who's really up to date or can really make a strong legal argument on why something should be different. But we haven't told you that. What are you going to try to do here today, sir?
I guess the first issue I have is the calculation the state came up with includes, it's not set off like my base pay, it includes overtime, which it's not guaranteed.
Okay, let me stop you right there. I'll tell you how Texas does that. Texas Family Code specifically includes overtime. The state's supposed to look at what your earnings have been over for the last 1 year time frame, and that is prima facie that's what it is going forward. Now, next year, if you lose overtime, or you actually, who do you work for, sir?
I work for a small company called Howard McInerney Equipment.
All right, then. Well, if you say you work for Tesla and and you got a letter from Tesla saying next year we're not going to be doing overtime, then yeah, we would take that. But from a smaller company, we would leave probably a little bit more. We probably even need testimony under oath from one of the somebody in personnel or human services to come, or human resources to come in and talk to give that testimony. But right now, the Family Code specifically says overtime counts, and what you've earned over the last 12 months is prima facie on what the court should use going forward. Again, I'm not a lawyer, but that's what exactly what it says, sir.
Okay, I understand, sir. I mean, I was kind of panicking earlier, to be honest with you, because this is the only other thing I can ask, and other than that, I can't really request anything else. Is it possible to hold the start time on this until July 1st?
Okay, that's the other one thing. So you heard the last hearing. I could technically start it as early as March the 1st, but based on it jumping like this and the fact that these children are younger and they're going to be paying child support for a lot longer, the best I can do, sir, is June the 1st. Yeah, that's the best I can do on this one. I wouldn't go backwards, but you're in future pay. I would go ahead and just go forward with that June date. And if you want to, I can go ahead and make the only other thing, sir, right now that I can look at is I see this, the health insurance is kind of, the reimbursement's kind of large. Health insurance is considered part of child support. And if you have a health insurance package that works for the kids where they are at this point, then the court could entertain order you to maintain the health insurance going forward, and just order you to pay child support to mom and make you do the health insurance and the dental and going forward, sir. But that's the only other thing I could possibly look at based on the pleadings I have before me at this time.
And I just talked to my bosses a while ago. It's still cheaper for me to just pay her than to put them on my plan. Our plan would be astronomical with them.
Where are you located, sir?
I'm in Temple.
Okay, you are local. Okay, just want to make sure. Yep. All right, sir, here's the deal. I can go ahead and make this a temporary order and let you go talk to a lawyer about things going forward. But again, sir, everything I've told you is part and parcel, 100% what the law is as far as your case is concerned. And when you want to change things from that, I've got to have compelling reasons, sir.
Okay.
So do you need additional time, sir, or do you want to go ahead and wrap this up today?
To be honest, I would like some additional time to at least speak to a lawyer to understand what legal reasoning is, because I'm not a lawyer. I'm a mechanic. I turn wrenches.
All right, well, here's the deal, sir. Are you asking, lawyers are expensive. My kid now is, just got a, they just started billing him after the first of the year at, $400 an hour. So, and he's a baby lawyer, but that's Austin. So how long do you need, sir? If you want to do something before the end of the month, then I could just leave this as is, but we're looking at something after the first. Okay, well, I can even come in at sometime in June, but I can order the new child support amount to start the first day of June or anytime before that date. I feel is that will equal things out. So how long do you think you need, sir, to talk to a lawyer? You need 30, 45 days? What are we talking about?
I would say less than that, to be honest with you. But whatever the soonest next date, I guess. I'll start making some phone calls, maybe within the week.
I know we might be a little crowded on some of these dockets, Ms. Hubbard, but let's go and see if we get this one wrapped up by the end of the month.
I just, for clarification, I just want to understand, if I show up to the next one and I don't have a lawyer, I'm not going to be in any trouble.
No.
Okay.
There's no requirement to have a lawyer, sir.
Your Honor, there are still spaces on the 625 docket.
Okay. Well, okay, that's more than a month out. I was going to probably get him in by the end of this month.
So by the end of May.
All right, well, we can do it. Let's go ahead and give, ma'am, I'm gonna go ahead and look at getting 625. Yeah, lawyers are expensive, and getting a lawyer to come in 10, 15, 20 days is super expensive. So, but again, I will look at making the new child support amount start the first day of June, even if we do go to 25th of May at a minimum, ma'am. And so you won't be behind any money, and it'll give him the opportunity to explore what his various options are. So if I do this on June 25th, and let's see if we can make prioritize this to get this one done early as possible on that date. It's 5 o'clock and they've been here all day. I tell you what, okay. So
Your Honor, I have a special setting. I have there's two special settings on 531. Mike could add it to the afternoon.
All right, 531. Yeah, I got a 9:30 and 11. Yeah, I could actually, folks, I can give y'all a special setting on Friday afternoon, May 31st at let's see, right now I've got 11:15 to 1 o'clock, and I can set y'all on the at 1 o'clock. This is I can give you an hour at 1 p.m. on that Friday, and that way we can start the new order for June the 1st. If there's not a new lawyer on this, if there is a new lawyer, we can look at setting up a temporary order and taking it from there. So, Ms. Larson and Mr. Roberto, can you appear at 1 p.m. on Friday the 31st? You're the only case I have at that time. That way you want to get caught in anybody's docket.
Yes, Your Honor.
Absolutely. Yes, sir.
All right, I'm gonna go ahead and make that Zoom code and get it out, and we'll see about getting you folks in here at 1 p.m. I'll have lunch after I deal with you guys, okay?
Yes, sir.
And when I leave for lunch after 1 o'clock, guess what? I'm not coming back. On Friday, are you kidding? And I don't even play golf anymore, and I'm still not coming back. So yeah. So, all right, guys. We'll Mr. Roboto, I understand it's a big change, and non-lawyers have the opportunity. I'll let you get that second opinion, like this was a doctor's thing. So we'll come back and I'll give you, and I'll get that Zoom code out for you immediately. So
I appreciate that, sir.
Since we don't have to do any orders at this time, is there anything else either of you are requesting at this point? Ms. Larson?
No, sir.
Mr. Roboto?
No, sir.
All right. See everybody on May 31, 1 p.m. Thank you.
We used weekly income for a security guard and a cashier. So weekly, it would be $706 for a security guard and $276 for a cashier. And that would be total $982.
Oh, okay. Y'all have calculated with him having 2 jobs.
Yes.
Court takes notice that Jonathan Moreno was served on August 16, 2023. Return of service is on file. Ms. Correa, go ahead and proceed.
Ma'am, can you state your name for the record?
Yes, it's Jacqueline Vela.
Ma'am, what are the names and ages of the children in this case?
It's Audrey Danielle Moreno. She is 6. Josiah Jr. Moreno, he is 5 years old, and Eliamani Moreno, she is 3 years old.
And who is the father of those children?
Jonathan Moreno.
Is there any reason to think that there's any man other than the person you just named that is father of those 3 children?
No, ma'am.
Okay, and you understand that he will be legally established today as a father of those children?
Yes, ma'am.
Ma'am, are you asking the court to be named joint or sole managing conservator?
Joint.
Okay, you believe you and the father can work together to make day-to-day decisions over the child's life?
Yes.
Ma'am, where does the father currently live?
At the moment, I do not know.
Does he live in Dallas County?
Yes, he was, but he recently told me like 2 days ago he moved in, so I'm not sure where is that located at.
Okay. Are you okay with the children's address to be restricted to Dallas County?
Yes.
Okay. Ma'am, what type of insurance do your children have?
Right now, they are on the government insurance at the moment.
You have any private insurance available at a reasonable cost?
No, I'm trying to get that figured out because I have kind of right now trying to fix their insurance since they were switching their insurance. So right now, at the moment, they're in the government insurance until I figure out what's going on with them.
And ma'am, you understand that the state is going to ask that you be ordered to continue to apply for government medical.
Yes, ma'am.
Ma'am, to your knowledge, is the father of these children disabled?
No, ma'am.
To your knowledge, is he incarcerated?
No, ma'am, he is not.
What types of jobs has the father had before?
From what I've known, he's worked as security and worked as a cashier at gas stations.
And how do you know that he held those jobs?
He tells me himself.
Okay. Ma'am, are you seeking retroactive support?
No.
So you're not seeking back child support?
No, but I would like to request it.
Okay, ma'am. What visitation do you think would be appropriate?
Well, how right now we're having it, but I'm kind of having trouble as well because he only gets his kids 3 days out of the whole month, which is every other weekend. Like this weekend, he had them. So I'm trying to also make it to the point where on his days off, if he could get the kids as well, but I'm not sure if we could try to have an agreement on that.
And ma'am, you understand that if the judge orders visitation today, that it is up to the father to exercise that visitation.
Yes, ma'am.
With that in mind, are you in agreement to the standard possession order?
Yes.
The state has calculated child support at $958. Are you in agreement with that?
Yes, ma'am.
And the state has calculated medical support at $383. Are you in agreement with that?
Yes, ma'am.
And retroactive, and I'll see if you clarify whether you are indeed wanting it. Retroactive support was calculated at $22,242 with a payout at $165. You've said you wanted it and then you didn't want it. Are you wanting the judge to order that judgment today?
Yes.
All right, ma'am. Your Honor, I would like to share my screen to present exhibits.
Go ahead.
May I do so?
Yes.
This is the information from the Bureau of Labor Statistics regarding what a cashier makes. This is the information that the state used when calculating retro and current support. This is treaties, so it is excluded as hearsay. So I'll stop sharing my screen briefly and then I'll share it again for a
Ms. Correa,
security.
you said this is who?
What?
What was the picture? You said this is who? I didn't understand what you said.
This is Bureau of Labor Statistics.
You said something else, but okay. I couldn't understand.
So it is the wages of a cashier according to the Bureau of Labor Statistics, which is a treatise produced by the government.
That's
is that
what
the
I-
part?
Treaties.
Okay, yes. Treaties. This is the treaties through the BLS and is for what a security guard makes. Okay. I asked that this be marked as Exhibit 2, State's Exhibit 2, and I asked that State Exhibits 1 and 2 be admitted.
They're admitted.
Okay, thank you, Your Honor. Ma'am, do you have any additional information that you would like to offer to the court regarding this matter?
No, ma'am, I do not at the moment.
Has there been, just one last question, has there been any family violence between you and the father?
No, ma'am.
Your Honor, I pass this witness.
Can you tell me what the number y'all have for gross wages? Because I'm not seeing how that matches up with the
For gross wages, okay, so we used weekly income for a security guard and a cashier. So weekly, it would be 706 for a security guard and 276 for a cashier. And that would be total $982.
Oh, okay. Y'all have calculated with him having 2 jobs.
Yes.
Ms. Vela, does he work 2 jobs at the same time, or he's had
No, he
job and then
basically
went to a
does.
different job?
Yes, he basically, the security guard is a full-time job and the cashier, it's a like part-time job since it's still the same boss he works for as from what he has told me.
Okay, so he has 2 jobs.
Yes,
You think it's reasonable that he makes almost $1,000 a week gross?
I'm not sure. He doesn't help out when I ask, so I'm not sure how much he really makes, but that he tries to show off, he does.
What do you mean he tries to show up? Does he own a lot of stuff or show up
Yes,
with
like
a lot of money?
yes, and also he comes whenever it's time to pick up the kids, he comes in different cars.
Some cars, what do you mean?
Basically the guy he works for, his boss, I'm not sure if he has a car lot, but from what he has told me, he says that his boss lets him get cars, and I'm not sure what that has to do, but from every time he comes, there's a different vehicle he has. So I'm not sure if his boss lets him use a car or I'm not sure what he does with the vehicles, but he has a different car every other week.
You think it's fair and reasonable that he would pay child support of almost $1,000 a month plus another $400 for medical?
No, I do not, but I mean, I just want him to be helpful and be with the kids. Like I told him, I didn't want to put the child support on him, but he hasn't been helping me like I've asked. I mean, if you could lower it down to help him, that's fine.
I'm not
really
trying to
don't.
help him. I'm just trying to do what's fair. I don't know. I'm not trying to represent him or try to, I'm not just trying to lower it, but it just doesn't make a lot of sense unless you have the information that tells me that it does make sense. I mean, the child support, and don't talk while I'm talking, please. The child support they calculated was on him making almost $1,000 a week. Please don't talk while I'm talking. That's an incredible amount of money. I'm not saying he doesn't make it. I don't know. I can understand he's working a full-time job, that makes sense. And then part-time, it's just kind of iffy, maybe as far as how many hours he may work. And you may say this is a fair amount, and that's what I'm trying to understand if you think this is a fair amount. To me, it sounds very high because I don't know that he's working full-time basically at both jobs. They did it at, I think it was about $800 or $700 on the first job and another $200 or $300 on the second job. So that's right a little bit less than $1,000 a week. That's how they got to these numbers. The numbers that we're talking about are him paying basically about $1,500 a month when we combine the medical support, the child support, and the payment on arrears. So I don't know this man. I don't know if that's correct or not. It sounds incorrect. Doesn't pass the smell test, if you get what I'm saying. But maybe you're right. Maybe this is what he earns. I can't set it on some arbitrary number just to help him out. I'm not trying to help him out. I'm not trying to get you to help him out. I'm trying to set it on a reasonable and fair amount based on what you know his income to be. I understand you haven't seen his pay stub, but you kind of know a lot more than I do. So I need you to kind of tell me what you know about his income, if you know anything.
No, I really don't. I just have the information that he basically tells me from what I've known at the gas station. They pay him, I believe, 13 an hour. And the security, I do not know how much they pay. I just know that he works the security full time. And when he's not, he goes and works as a cashier.
How many hours do you think he works as a cashier per week?
I do not know, sir. That's the iffy part, that I only know some certain things because he doesn't tell me the full story.
Okay, so do you want me to set these large amounts here that the state has asked for?
Yes, I do.
Okay. All right, default judgment granted, paternity established, no finding of family violence. Parties who appointed joint management conservatorship, child support 958, medicals for 383, retroactive judgment payable at $165 a month until paid in full. Ms. Correa, was that $22,042?
$22,242.
Okay. Humongous judgment. All right, court costs as billed. The Attorney General's office will draft an order based on what we've done today. He may appeal this decision if he doesn't believe it's fair and right. Obviously, he's not here to tell us any information because then I could have hurt his side. And then we'll go from there. The Attorney General's office will email you both a copy. Y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
Thank you.
I'm a good father. I do what I'm supposed to do with my kids. I get them every 2 weeks, and I do what I'm supposed to do for my kids. Seeing as if the mother of my child kind of agrees with that as well, I kind of feel like that's a high amount. The job before that, I didn't have overtime either, and I was on that job for 1.5 years.
I don't care about your other job. People see the guy go visit with the other kids and that kind of thing, and they call him daddy. I don't know. I don't know what the particular issues are. But Ms. Dixon, do you want me to include the other 2 kids, or are you not really sure yourself? Mr. Jones, last time we reset your case because you were going to hire an attorney, you did not hire anybody, did you?
No, sir.
All right. Ms. Atchfield?
Thank you, Your Honor. We have a partial agreement on this one, so I'm going to read the agreed portions into the record. The parties agree that they will share joint managing conservatorship. The parties agree to have a residency restriction to the Dallas and surrounding counties. The parties agree that there's been no family violence and no request for non-disclosure. The parties agree to a standard possession order for the father. The parties agree that the father is employed at making $24 an hour, and they agree for state medical to be paid at $164. The parties agree that the father has 2 other children that do not reside with him, and he does not pay child support for. And that is all the agreed portions. So I will take testimony regarding child support, Your Honor. The state calls Shamika Dixon. Ms. Dixon, will you please state your full name for the record?
Yes, Shakima Dixon.
And can you state the names of your children and the age?
Yes, ma'am. Madison Jones, she's 5, and Messiah Jones is 4.
Ma'am, did you hear the agreed portions that I read into the record?
Yes, ma'am.
And do you agree with those provisions? And do you believe that an order with those agreed portions is in the best interest of your child?
Yes, ma'am.
And are you asking the court to approve those portions of the agreement?
Yes, ma'am.
And do you also agree that there's been no family violence between you and the other party? And do you also agree that there's no reason for non-disclosure at this time?
Correct.
And Miss Dixon, do you agree that Mr. Jones makes $24 an hour?
If I'm not mistaken, I think he said 21 when we were talking to the previous man before the breakout.
So it's your understanding that he makes $21 an hour.
Correct.
Now, the state is proposing child support in the amount of $732. Are you in agreement with that?
I don't think that's right based off his pay rate, so no.
And what do you think his child support should be set at?
I think it probably should be set less, only because if he makes 21, I don't think, because I think the numbers were based off 24, but if it's 21, I don't think it should be 7.
Your Honor, I pass the witness.
Okay, go ahead, next witness.
The state calls Mr. Jones, Mr. Major Jones. Mr. Jones, can you state your name for the record?
Major Jones.
And can you state the name and ages of your children?
Madison Jones, she's 5, and Messiah Jones, he's 4.
Mr. Jones, did you hear me read the agreed portions into the record?
Yes.
And do you agree with the agreed portions that I read?
That pay rate was incorrect. It was $21 an hour. And the only part that I'm kind of not in agreement with is just how high that is. And that's the only part I'm not in agreement with.
But the agreed portions I read earlier, are you in agreement with those? Not the pay rate.
You're speaking like the agreements we have as far as like what you said at the very beginning.
Yes, sir.
Yes, that part.
Okay, and
But
do
not-
you believe that that those provisions are in the best interest of your children?
Yes, ma'am.
Okay, you heard me read that you were making $24 an hour.
Yes.
Are you in agreement with that?
No.
What are you making, sir?
21.
Sir, the state is proposing that you pay child support in the amount of $732. Are you in agreement with that?
No, ma'am.
And why are you not in agreement with that, sir?
I just kind of feel like, to be honest with you, I feel like that's a kind of high amount. I kind of think that's based off that $24 an hour thing that you were just talking about that he had on the paper, which was incorrect. But even with that, you know, I know that they're not going to consider anything that I do for my kids and none of that, but I'm a good father. I do what I'm supposed to do with my kids. I get them every 2 weeks, and I do what I'm supposed to do for my kids. That's just a high amount, seeing as if I have to pay that and the Medicare and the insurance on top of that. It's just going to hinder certain things that I do with my kids when they do come over. So I'm seeing as if the mother of my child kind of agrees with that as well. I kind of feel like that's a high amount.
If you're given credit for the 2 other children you have that you're not paying support for, the state will propose $604 for child support. Are you in agreement with that?
No, but yes. No, I don't really, to be honest with you, I agree with paying the children's health care, of course, yes. And, you know, giving the mother of my child whatever she needs as far as that one. But it's like, no, I don't agree with that, to be honest with you.
So you also do not agree to pay $604, sir?
Well, can I speak to the mother? Can I ask the mother, does she agree with that just before I, agree with that?
No, sir, just please answer my question. Are you able to pay $604? I pass the witness, Your Honor.
I got a couple questions. Okay, let's first talk about besides view the amount. We kind of went through different numbers. So can you verify they calculated based on 21 and not the 24? Maybe it was just a bad note that got passed to you.
It was calculated at 24 initially for the
Okay.
734.
Do you have any note as to why they did that?
No, Your Honor.
Okay. What's your
But
exact? Yes.
I'm sorry, Your Honor, with the defendant, with Mr. Major having 2 kids, when giving him credit for that, it lowers the amount to $604.
Well, right, but it's still the wrong number, right? Because it's not 24, it's 21.
Just give me a second.
Mr. Jones, what is your exact pay rate? $21, and is there some change?
It's like $21.37, something like that.
How many hours a week do you work?
My full 40.
You ever work overtime?
No, sir.
You've never worked overtime?
At other jobs, not at this job, no.
How long have you been at this job?
This one, I just started this one back in, what was it, October. The job before that, I didn't have overtime either, and I was on that job for a year and a half.
I don't care about your other job.
I'm sorry. I apologize. My bad.
Okay. And then tell me, I don't understand what's going on here with these other two kids. I don't want to go into detail about them because they're not really what we're here talking about, but you have two kids with Miss Dixon, and then you have two additional kids that are not with Miss Dixon. Is that right? The right summary?
Correct.
And you're not married to either one of those two mothers from those other two kids?
No, I'm not married. Correct.
And you haven't done a child support order for either of those two kids?
No, I'm not on child support.
Have you done an acknowledged paternity saying that you were the father of those two kids?
Yes, those are my kids.
I'm not asking about oral. Have you done it in writing?
Like, are you saying, did I sign the birth certificate?
Did you sign acknowledged paternity when you were in the hospital? Did you go to the hospital when they were both born?
Yes. All my
Okay.
kids.
Did you sign a paper for them?
Yes.
You have a copy of it with you?
Nah, I don't even know what. No, I don't have that.
Okay. Are those two kids older than Miss Dixon's kids or younger than Miss Dixon's kids?
One of them's older and one of them's younger.
All right. Ms. Dixon, I need to understand what's going on with these other two kids. So, according to state law, I should not give him credit for the other two kids. The only last exception would be that you acknowledge that absolutely he's the father, even though he hasn't done DNA testing and there's no court order that those are his kids. Sometimes people see the guy go visit with the other kids and that kind of thing, and they call him daddy. I don't know what the particular issues are. But Ms. Dixon, do you want me to include the other two kids, or are you not really sure yourself?
I know about the first kid, but like I said, I didn't know about the other kid because that's his personal life. I don't get into his personal business, so I didn't know about that one, but I did know about the oldest child.
Okay, so you're okay with me acknowledging that he has one kid, not two?
You can acknowledge both of them. That's fine.
With one or the other, because I don't know the whole story. So if I do,
I don't know. Like, I just know, like I said, he said he has two kids, but we haven't been together in years, so I was unaware of the second child, the other child, until today when he mentioned it in court. But the first one I did know he had.
then let's just include the one child, because really, legally, I'm not supposed to include any. Okay. All right, Miss Etchefiu, I came up with 3704 for gross. Is that what you came up with on $21 an hour?
I came up with 3740, but we'll go with your number, Your Honor.
Okay. Then what do you, if we're doing 22.5% with the medical at 164.
164.
All right, so I came up with at $21.37, your gross monthly wages before taxes is $3,704. Then your bring home pay after that would be approximately $3,142. That's kind of approximating what your taxes, your Social Security, and Medicare would be. If I subtract the 164 from that, that gives us to $2,978. State law says you should pay 22.5% for two children in this case and one other child in another case. And that gets us to $670. So that's what the child support needs to be. It's just a math calculation. And so that's what I'm setting support on. The parts y'all agreed to, those are all fine with me. And those will also be part of the court order. The Attorney General's office will draft an order based on my ruling, and then they will send you a copy of that. And then make sure that all payments that are made at the child support office, they'll send out a withholding order to take it out of your check and maybe divide it up per check, depending on how you get paid, if you get weekly or whatever, so that at the end of the month, the full payment is made. All right. That's all we need to discuss today then. That'll be the order, and y'all are done with court today.
This is a very toxic situation.
The reason it's toxic is because of Jennifer.
Hold on, Mr. Sidoni.
And it's okay for Jennifer to tell them that their last name is disgusting and they can change it to her new husband's name. If I ask them, what's going on? How's school going? They tell me it's none of my business. Because Jennifer told them that it's none of my business.
Sidoni,
they don't have to tell me anything.
Are you in agreement to that amount, sir?
No, I pay her T-Mobile phone bill since December of last year. Her daughter.
I thought the daughter was 5.
Your Honor, this is a partially agreed order. The state is requesting to read into the record what has been agreed to by the parties.
All right.
Your Honor, the parties agreed to be named as joint managing conservators. The parties agreed for the custodial parent to carry the health insurance for the child through an outside source. Also, for the mother to carry the dental and vision insurance through her employer for the child. The parties agreed for the non-custodial parent to be named as the child's biological father. The parties agreed to the child's last name change to be McDowell-Jackson. I believe that is the extent of the agreement. The issues that are not agreed to are the issues relating to child support, visitation, and retroactive support. This time, Your Honor, the state would like to call Ms. McDowell. Ms. McDowell, can you just state your name for the record?
Kenya McDowell.
And Ms. McDowell, can I get you to state the name of the child or student that we're here in reference to?
Austin Jack McDowell Jackson.
And the name of the child's father?
Gamel Jackson.
And did you hear what I previously read into the record that was agreed to by the parties?
Yes.
And are you still in agreement with those terms provided to the court?
Yes.
Just one moment. Just confirm there's been no issues relating to family violence, is that correct?
Correct.
And the child is currently receiving insurance through the marketplace, is that correct?
This will be the first month that we do it, yes.
And is that at a cost of $14 per month?
After she did the math, yes. She divided it by 3.
And are you requesting that the father pay the total of $14 per month for the child insurance?
Yes.
And as it relates to the dental insurance for your employer, is there a cost associated with that dental insurance?
The dental insurance is $45 a month. The dental and vision.
And is that for just the one child or is that for all children?
That's for myself and 2 dependents. So she divided that by 3 as well.
And that is a total cost of $15, is that correct?
Yes.
All right. And so are you requesting that the father pay a total of $15 per month for dental?
Yes.
And as it relates to the current child support, do you understand that the state had to use the father's income as reported to us in the amount of $3,620 per month and requesting that the father pays child support based off of that at a total of $1,231 per month?
Yes.
Just one moment. My apologies. I did misstate that. That was in reference to the retroactive support. As it relates to the current child support, the state has used the father's quarterly wages that were reported to us, and that total is at $7,874 monthly. And based off of that amount, the state has set the child support, which was previously provided, in the amount of $1,231 per month. Are you in agreement to that amount?
Yes.
And do you understand that if ordered, these payments should begin on December 1st, 2023? Do you understand that as well?
Yes.
And now, as it relates to the retroactive support, are you requesting retroactive support?
Yes.
And just one moment here. The state has calculated retroactive support in the amount of $3,620, which includes a credit of $2,535, and requesting that the father pays that back at $68 per month. Are you in agreement to that amount as well?
Yes.
And how old is the child here in this matter?
He'll be 4 months on the 17th of this month.
And just to confirm, you are in agreement to the credit, which was provided in the amount of $2,535. Is that correct?
Yes.
Excuse me, I misunderstood. What is the actual retroactive child support amount that you're requesting after the credit?
$3,620.
Okay.
All right. Paid at $58 per month.
Got it.
As it relates to the visitation, are you in agreement to the father having a standard visitation agreement? What is the current visitation agreement that your parties have?
Well, currently, I mean, there's no visitation like schedule set right now. I know she was saying that the standard was for him to have him every other weekend, but he works on the weekends. So she said that we could work something out on something outside of the standard. And so we were going to do that outside of here. But she did mention that the standard was overnight visit.
Ms. McDowell, again, what is the current visitation agreement? How is the child currently visiting with the father?
Just whenever we schedule it.
And what is that schedule currently, ma'am?
The last time he had him was on Saturday for a couple of hours.
Has the father had any overnight visits with the child?
No.
Is there any specific reason why the father hasn't had any overnight visits with the child?
Whenever he had him on Saturday, he overfed him. I know I sent him with 2 bottles and they were supposed to be given 3 hours apart, and he gave him both bottles in the span of like an hour and 15 minutes. So I had to go pick him up because he had given him all the milk. And it's kind of like hit or miss. Even though I think he will take a bottle from him, he's just
All right. And just to confirm, you're stating that you don't feel that the father should be given standard visitation agreement because the child is currently being breastfed. Is that correct?
yes.
Could you provide the father with all the things that the child needs when the child is going to be overnight, if the child is ordered to be overnight?
Yes.
All right. Nothing further from this party, Your Honor.
All right.
At this time, Your Honor, the state would like to call Mr. Jackson. Mr. Jackson, can I get you to state your name for the record?
Mel Jackson?
You are the father of the child here in this matter, is that correct?
Yes.
And sir, did you hear what I previously read into the record that was agreed to by the parties?
Yes.
And are you still currently in agreement with those terms, sir?
Some of them.
Could you explain to the court what exactly you're not in agreement to that you previously agreed to?
The child support.
That was not being agreed to, sir. Again, what was agreed to was joint venture and conservatorship. The child would receive insurance through the marketplace, that the child's last name would be changed, and that you would be named as the child father. Of those 4 things that's been provided, sir, what are you not in agreement to?
Oh, no, I agree with it.
And sir, as it relates to the current child support, do you understand that the state has used your current income, which has been reported through our sources, in the amount of $7,874.85 to calculate your support, sir?
I understand.
And sir, based off of that, the state is requesting that you pay a total child support in the amount of, give me just a moment here, $1,231 to begin on December 1st, 2023. Are you in agreement to that amount, sir?
No.
Just explain to the court why you're not in agreement to pay the support based off of your current wages.
Because a lot of those hours were overtime hours, and I don't get like that anymore.
Sir, do you understand that the state uses your reported wages, which does include overtime wages?
I understand.
All right, sir. Other than you just not wanting to use your overtime wages to calculate support, is there any other reason why you're not in agreement to the support is calculated?
That's it. And most of that money came from overtime.
And sir, as it relates to the retroactive support, the state has used your current child support obligation, if it was to be based off of the $1,231 per month, to calculate what the retroactive support would be. The state has given you credit for the amount of $2,535 and requesting a judgment in the amount of $3,620 to be paid at $68 per month. Are you in agreement to that amount, sir?
Yeah, I guess.
And sir, are you in agreement to paying the medical support in the amount of $14 per month for the child?
Yeah.
Agreement to the dental support amount at $15 per month.
Yeah.
As it relates to the visitation, sir, are you requesting to have standard visitation with the child?
Yes.
And so do you feel that you are capable to have the child on a current standard visitation schedule?
No, because my schedule changes.
So again, sir, what are you
at least maybe once or twice a week.
When, sir?
On my off days, but my off days changes every week.
Do you want to provide to the court your schedule, your work schedule, sir?
Okay, so my off days right now is Monday, Tuesday for this week, but next week it'll be Tuesday, Wednesday. Then the week after, I never have weekends off. Most of the time I don't have weekends off because my job goes by seniority and I don't have that much seniority.
So, sir, are you requesting that the parties just have a visitation agreement as agreed to by the parties?
Wait, say it again?
Are you requesting that the parties, instead of having a standard visitation schedule, being that you don't have the ability to visit with the child on every weekend, that the parties just come to an agreement as it relates to when you will have visitation with the child?
Yeah.
All right. Do you have any additional information you'd like to offer to the court, sir?
No.
Nothing further for this party, Your Honor.
Mr. Jackson.
Yes, sir.
If I put it in here as agreed by the parties, that means anytime Miss McDowell doesn't agree, that means you get no visitation. You understand? Is that what you want me to put in this order?
No, I would like to spend time with my son.
That's what I'm thinking. And so as agreed by the parties is not a valid visitation schedule. I can put a standard visitation schedule in place, which means that the two of you can agree to any visitation. But barring an agreement, then you would still be able to visit as per that standard visitation arrangement. You understand?
Yes, sir.
So are you asking for a standard visitation?
It'd be standard.
All right. Now, you say that you don't agree to the $1,231 per month in child support. Is that correct?
Yes.
And your reason being is that a lot of that includes overtime. Is that correct?
Yes, and they have cut hours when it comes to they don't offer overtime no more.
You realize that the AG doesn't have a crystal ball. They can't look into the future. All they can do is look into the past. And they look in the past and they see that you made X dollars. And based upon the amount of dollars that you receive, then they have to set child support based upon that amount. Do you understand that?
Yes, sir.
That's the reason why they arrived at $1,231. Now, if your wages change within the year, then you can do a year from now, you can repetition the court and ask that your child support be modified downward if you're making less money. However, if you're making more money, then of course your child support will be modified upward. Do you understand that?
Yes, sir.
You have any questions?
When can I come back to the court with my lawyer?
I'll tell you when we finish this, okay?
Okay.
Yeah, all right. Mr. Tatum is going to email both of you a copy of this order, which finds that the two of you to be joint managing conservators, finding you to be the biological and legal father of the child, ordering you to pay child support of $1,231. You'll have a standard visitation arrangement, finding you to owe retroactive child support in the amount of $3,620, payable at $68 per month, beginning December the 1st, that you're going to pay cash medical of $14 and cash dental of $15. Now, you have the right to appeal this decision, so listen carefully. You have 3 working days which to appeal this decision. So you need to get you an attorney, have him appeal, okay? Now, you don't really have to get an attorney to appeal. You can appeal on your own, okay? This is out of the 255th court, and you have 3 working days in which to appeal. Now, if you appeal, then the court will give you what's called a trial de novo. They'll allow you to tell the story over again. And since the court is not going to hear it in 3 days, they'll probably set it off for some time. That's when you probably want to get you an attorney so your attorney can tell your story to the judge. You understand?
Yes.
Yes.
You have any questions?
That's it.
No.
Now remember, you only have 3 working days to appeal.
Okay.
All right. You have any questions, Ms. McDowell?
When would the birth certificate, like we would be able to get a birth certificate with the new name, correct?
The state is going to submit a change of the name to the state registry. Yes, sir,
Oh,
Mr.
yeah.
Tatum.
The parties will need to use the order to get the name changed on our documents. It would take this
Sir,
order.
y'all should be able to submit to the state registry a change of the name. And then they can go and get a new birth certificate in about 8 to 12 weeks.
Okay.
But it's up to the state should put that name change.
Okay. Okay.
Okay. Either one, y'all have any additional questions for me?
And while he's appealing, if it's before December 1st, does the child support take effect December 1st, even though he's appealing, or?
Yes, ma'am. His child support starts December the 1st.
I have a question.
Yes, sir.
I did not add a phone bill onto the cost. Does that count for anything?
Your what?
Phone bill onto the cost. Does that count for anything?
Yeah.
What phone bill? I don't understand.
I pay her T-Mobile phone bill since December of last year. Her daughter.
I thought the daughter was 5.
No, my daughter's relationship. This is pertaining to our child that's 3 months. He'll be 4 months on Friday.
Oh, well, then that's something you did arbitrarily, Mr. Jackson. It has nothing to do with this order.
Okay.
Okay.
Thank
Y'all
you.
can press leave, and Mr. Tatum is going to email y'all a copy of the order. Thank you both. I appreciate your
Thank you.
time.
We can't go back and talk to Mr. Barbie. I'm sure Miss Osborne or whomever will say it was his intention that Miss Barbie gets nothing.
The record, this matter is before the court. Account of a motion filed by the estate of Anthony Barbie, the defendant herein, who's now deceased, and a motion to show cause against the plaintiff relative to disposition of a 401k in which Mr. Barbie, who's now deceased, was a participant. Ms. Barbie was the beneficiary of that 401k, which was never changed subsequent to the judgment of divorce. In any event, this hearing is being conducted via Zoom this morning. Present is Attorney Mark Sandretto, representing the estate of Anthony Barbie. It's like Gina Osborne is present. I believe she's the personal representative of the estate. Is that correct, Mr. Sandretto?
That's correct, Your Honor.
All right, good morning. In addition, Attorney Nicholas Darren is present, representing the plaintiff, former spouse Linda Barbie, and Miss Barbie appears to be present. Good morning, everyone.
Morning, Your Honor.
Morning, Your Honor.
Court has reviewed the pleadings. Court has also read the case of the Reed Estate versus Reed, 293 Mishap 168, a 2011 Court of Appeals case, which is most relevant, and both parties have addressed and cited that case in their respective briefs. So there's no need to recite what or has already been stated in your briefs, but I'll give the parties just perhaps a short period of time to anything additional. And Mr. Sandretto, do you want to begin?
Thank you. Thank you very much, Your Honor. From the perspective of Ms. Osborne, this is a pure matter of this is a purely legal matter to be decided by the court. We believe that Reed v. Reed, a reported course from the case from the Court of Appeals, is the controlling authority here. We believe that there are no factual distinctions of any material sense with respect to the consent judgment that was, or excuse me, with respect to the judgment of divorce that was at issue in Reed compared to the judgment that was at issue here. Both of those are similar in the sense that both judgments provide for the disposition of qualified IRAs, including a 401k that were to be retained by in both cases, a decedent who passed away after the judgment of divorce, but prior to the execution of a change of a beneficiary designation for the 401k. And under those circumstances, that the claim that although the beneficiary designation may control for purposes of the initial disposition of the money from the custodian of the 401k account, the ex-spouse in both cases, by virtue of relinquishing any claims to those 401ks in the context of the consent judgment of divorce, has relinquished those claims. And that there is no facts before the court that would permit a finding that there is any type of that there is any excuse me, that there's no finding, there are no facts alleged before the court that there is any suggestion that there should be a disposition of that there should be a disposition otherwise. I would point out that with respect to the brief that was submitted by Mr. Darren, he points out, he makes argumentation regarding his position that there is no waiver as such in connection with the consent judgment that is at issue here, and that there was an express waiver in Reed, and that is the distinguishing factor between the two cases. I don't believe that's an accurate recitation of the Reed case. I mean, in both cases, there is a disposition of the 401k, identifies to whom the 401k is to be disposed. And then there is a statutory insurance provision common in Michigan judgment entries that pertain to insurance contracts, annuities, and endowments that may be subject to 401ks. But the fact of the matter is the waiver that's at issue, it doesn't say, quote, I waive claims to the 401k benefits. What it is the relinquishment of the right to the 401k beneficiary that is agreed to in connection with the consent judgment. That, I believe, is the express waiver that the court in Reed was referring to. It's not referring specifically to the insurance language in the statutory insurance language that we see on page 171 of Reed. So it is, and of course, it is the requirement and legal duty of the personal representative to marshal assets for the benefit of the estate to be distributed in accordance with the estate. In this case, it's an intestate estate, but in accordance with the statute of descent and distribution.
Thank you. Mr. Darren, response?
Yes, Your Honor. I mean, I do believe that the Reed case is distinguished from ours in this case. While Mr. Sandretto was pointing to the statutory waiver, that there is additional waiver language that's in Reed that's not in this case. It states specifically, it shall be the responsibility of each party to make the appropriate changes in beneficiary designation, and it goes on for another run-on sentence there about that. That's not in the Barbie judgment. These parties got divorced. That property was awarded to him. There's not really much dispute to that. But he then, we want to look to facts. He had all that time to change the beneficiary. He was advised by counsel. He had counsel at the divorce that he would have had to do that. Unfortunately, we can't speak to Mr. Barbie or what his intentions were. So that's what the beneficiaries are for. He left Miss Barbie as a beneficiary for a reason. If you want to say, oh, he forgot and now this is a fail-safe, we can't go back and talk to Mr. Barbie. I'm sure Miss Osborne or whomever will say it was his intention that Miss Barbie gets nothing. But he had time. Changing a beneficiary, as the court knows, is not a difficult process. It's one phone call and a piece of paper, and the beneficiary gets changed. He didn't do that in this case. The property was awarded to him. He did with it what he wanted. He left her as the beneficiary. I mean, the Reed case is distinguishable because there's implicit and explicit waivers in that judgment. Those aren't in here. There's no waivers or instructions for what people are supposed to do. It's just, hey, it's yours, and it's kind of do with it what you want. He did with it what he wanted. He left Miss Barbie on there. I understand, and the one thing too, is not mentioned is it's not that this is the only asset of Mr. Barbie. He didn't disinherit his entire family in exchange for Miss Barbie. The estate has been funded by other mechanisms and other things that were given. He made other people beneficiaries on other accounts. So this isn't the only account, and it slipped his mind to change her. There's other accounts, there's other stuff out there that went into this estate. So, Your Honor, I think the Reed case is clearly distinguishable because of especially the way the court treats it and kind of goes to these waivers. And then on top of that, he was in control of this account and he made his decision to leave the beneficiary. That's what we look to. That's why the beneficiaries are there. If we just were going to ignore the beneficiaries on this, and we'd be in court on every estate because, he didn't mean to leave it to this person. That's what the beneficiaries are for. He had the ability to change it. He didn't. I think the money should be left with Miss Barbie, and Fidelity contacted her the same as they would as the fiduciary for Mr. Barbie, fulfilling his wishes of giving the money to the beneficiary.
Court notes, Mr. Darren, you represented Miss Barbie in the divorce. As Miss Barbie being the plaintiff, did you prepare the judgment?
I did.
All right. Did Mr. Barbie update the designation beneficiary subsequent to entry of the judgment of divorce?
Your Honor, I didn't represent Mr. Barbie. I wouldn't know. He was represented by Miss Rourke at the time.
Has anyone been in touch with the plan administrator? Is there any indication that Mr. Barbie changed his position and updated renewed the designated beneficiary as Linda Barbie subsequent to entry of the judgment?
I don't know, Your Honor, and I don't know if that would really be relevant. I understand.
Well, it would be relevant as to the intent of the parties. There's a suggestion that they reconciled, and that was Mr. Barbie's intent. But the court is of the opinion that the Reed case is right on point. The issue for this court was the waiver by the designated beneficiary, Linda Barbie, was it clear, unequivocal, explicit, voluntary, good faith, consent, judgment, divorce? And the court determines, yes, it was. She gave up her right to that 401k. It's clear under the terms of the judgment. Counsel for plaintiff prepared the judgment. Perhaps if the defendant would have prepared the judgment, it would have been a little clearer in terms of explicit language. There is a waiver, the standard insurance provision waivers. But notwithstanding that, the court finds that the Reed point is on point and that the proceeds of 401k should be paid to the estate of Anthony Barbie. Has the administrator paid out any proceeds yet to Linda Barbie?
Yeah, this was over a year ago, Your Honor. He died. The proceeds were paid and have been already transferred into a separate account.
Court ordered that Linda Barbie return those funds, 100% of those funds, to the estate of Anthony Barbie. I don't know if those are still preserved, but again, if the court will order that, if to the extent that Ms. Barbie sells those funds, that those shall not be expended.
Your Honor, I don't think the return is just that easy. If the money has been placed into qualified funds, there's penalties and tax things. That's not my client's fault that Fidelity gave her the money. So she's got to eat thousands. I mean, if we're talking about 150 grand, she's got to eat thousands in penalties and things like that because of Fidelity's mistake.
Okay.
Or Fidelity's actions that are consistent with the statute.
There's no mistake on the part of Fidelity. The court would acknowledge that. I think Fidelity is duty bound to pay those proceeds to the designated beneficiary, Linda Barbie. But notwithstanding that, the estate of Anthony Barbie is entitled to those funds. I don't know what to suggest to counsel, but obviously, yeah, that's a valid point, Mr. Darren. Obviously, Ms. Barbie shouldn't have to incur penalties or taxes. So I'm not sure, perhaps counsel between the two of you can figure that out and determine the appropriate amount to be paid so that Mr. Barbie is not saddled with any penalties.
I will confer.
Tax consequences.
I'll be certain to, I will confer with Mr. Darren on that issue.
And if necessary, you can come back before this court, but it is the order of this court that the estate of Anthony Barbie is entitled to the 100% of the proceeds from the 401k. It's unfortunate that was not brought before the court previously, but even if it was and they not pay out the proceeds, I believe that Fidelity is duty bound to pay those proceeds pursuant to ERISA to the designated beneficiary, which is Linda Barbie. But after that, the state court has the authority to address that issue, and the court again believes that the Reed case is on point. So court will enter an order. Mr. Sandrotti, you prepare the order that the proceeds of 401k be payable to the estate of Anthony Barbie forthwith. And yes, if in fact that you need to address those tax consequences, it's a valid point. If counsel cannot work through that with the assistance of an accountant, a financial advisor, then you can come back before this court.
Thank you, Your Honor.
Okay. Thank you very much, Your
Honor. You'll prepare the order?
Yes, Your Honor.
Anything further, Mr. Darren? I'm sorry.
No.
All right, that will conclude this matter. Everyone can zoom out. Have a good rest of the day.
I've been struggling, and I don't feel like I should have to ask my ex-husband for money.
1,700 might be too high, even though that's guideline support. What would you be asking the court to set support at?
Overtime is not guaranteed nor always offered. I'm currently working the overtime when it's allowed, so that way I can compensate for paying for the medical and paying for child support.
We're requesting a final order today. I think parties are in agreement that the source of the medical insurance has changed from Ms. Miller's employment to Mr. Stiegel. The prior order was a deviation by agreement. However, the insurance would be the material and substantial change we need to go forward today. The state's calculated that guideline child support based on Mr. Stiegel's income for 2 children and no other children will be $1,707. I believe, and that's giving him credit for $580 spent on health insurance each month. I believe Mr. Stiegel is asking the court to deviate from that. And as far as any arrears on the case, child support as of April 30th, 2024 is in 0 arrears. Medical support is $23 in arrears, and dental support is $196.81 in arrears.
All right. And there was an order for super modification of child support and confirm arrears back in December of 2019. This is the order that is controlling at this time?
Yes, Your Honor.
Okay. All right, then the court will take judicial notice of the 2019 order in accordance with the Texas Family Code. My understanding is that, well, first off, I understand that the state is saying that y'all were in agreement to deviation from guideline child support back in 2019. Under Texas law, that is mandatory to remain in effect for a minimum of 3 years. That order is more than 3 years old, so the court can, in and of itself, at this time, look at a modification based on a change of circumstances or anything else, because again, it's more than 3 years old, and deviation from guideline is only locked in for that time frame also. So at this time, I'm going to go ahead and let the state call you both as witnesses. Let the state let y'all tell the court what you're requesting we do here today, and Mr. Stegall, tell the court why you feel that a deviation is appropriate in your case. You've sat through a few of these hearings today already, listening to them. You see what the standard is. I've got to have a legal reason, sir. I just can't do it based on the claim of hardship or anything along those lines. I've got to hear what the specific circumstances are and whether or not they come up to the criteria of allowing me to do so. And sir, if you want to go ahead and do like the last gentleman, see if I can get run this by a lawyer before you come in here and make this a final, I'll let you tell the court that you, if you want to do that, and I can always just do a temporary order and let you come back and speak with your own counsel.
In the prior order, you were covering insurance through your employer. Is that correct?
Yes, ma'am.
And at this time, you're in agreement with Mr. Stegall covering the insurance costs for the children?
Yes, ma'am.
Okay. As far as child support, are you requesting a deviation today as well, or just guideline support?
So I think what they're asking is a little too high, but I do agree that I should get more money because I've been struggling doing this on my own.
Okay.
All right, okay, bro, I'm sorry, I hate to interrupt. All right, ma'am, Jordan turns 18 in August?
Yes, in August.
All right, so child support for her would end, and she's graduating this year, correct?
Yes.
So that means child support for her ends after the first day of August. That would be the last child support payment at that time. And then it would go down to having just one child still left. I'll have the state tell you what those figures are, and you can see whether or not what you might want to do one way or the other. But again, guideline is guideline. So I'll let the state tell you what those two amounts are. One for the next 3 months, and then finally the one that would start on September 1st with the one child still under 18 and still in high school. Thank you. Or still in school, sorry.
Ms. Miller, those amounts, the guideline support calculated currently would be $1,707. And once Jordan turns 18, it would go down to $1,366.
Okay.
And as far as the prior order, you had agreed to a deviation from guideline child support of $966 to $540. And the reasons given in the order were because additional periods of possession were occurring, and also Mr. Stegall was paying for sports programs at that time. Is he still doing those things?
So none of the kids play sports. Jolynn, our youngest, is in a band, and we have split the for men. We split that. We split. That's. I feel like lately I've had to ask him for more money because I've been struggling, and I don't feel like I should have to ask my ex-husband for money. It's just not something that I feel comfortable doing. I don't agree with the $750 anymore. Like inflation, everything. Like, I mean, I've dealt with that for quite a while.
Okay, here's the deal, ma'am. You're still cracking up a little bit on us, but here's the deal. You don't have to agree to anything, ma'am. The law says the percentages are the percentages, and if you request the court to order the percentage, the percentages that are due for the two children and then the one child, the burden of proof falls on Mr. Stegall why the court should do something different, not on you have to request it, okay?
Okay.
All right, you might want to try to go outside, ma'am, because again, you're still not getting a great signal. Thank you. I hope it's not storming out there already, so you know.
No, it's not. It's bright, but.
Okay, that sounds a lot better now. Thank you. Maybe the witness and server.
I guess because you stated that you think that the 1,700 might be too high, even though that's guideline support. What would you be asking the court to set support at?
And Ms. Hubbard, it's only another 3 months on that. I would be okay. Yeah, I would do it. I would.
I guess.
But yeah, that's 3 months worth of. So yeah, go ahead, ma'am. Is there an amount you're requesting?
The $1,300, like that I was supposed to pay for just my one kid.
So you would request that child support be modified today to the $1,366 and just continue going forward until Jolynn is graduated or until we come back to court to modify?
Yes.
Okay. Is there any other factors you think the court needs to consider today?
No.
Okay. Now, there was a note on here that you are concerned about your address or phone number being included in this order. Is that true?
No. So we did have issues in the past when we were together and when we first split up, when we first had the order, but we co-parent and there's no those.
So,
Ma'am, yeah, we got a loud connection. But I'm understanding is, ma'am, you have no problem with your information going to Mr. Stiegel now, right?
No.
Okay, good enough. All right, thank you. You may proceed, Ms. Hubbard.
Your Honor, that's it. I pass the witness.
All right, Ms. Miller, we'll be right back to you. I'm gonna go ahead and let the state call Mr. Stiegel at this time. You may proceed, Ms. Hubbard.
And Your Honor, just on a comfort point, Miss Miller, if you want to step inside while I'm talking to Mr. Stiegel, so long as you can hear us, that way you can be in the air conditioning.
Okay, thank you.
The state would like to call Jeremy Stiegel. Sir, will you state your name for the record?
Jeremy Douglas Stiegel.
And sir, are you in agreement with carrying the medical insurance for the children?
Ma'am, I volunteered to take on that responsibility.
Okay, I asked a yes or no question. Are you in agreement with carrying the medical insurance for the children?
Yes.
And that's through your work?
Yes.
And you are in agreement with covering the children on your wife's dental insurance, is that correct?
That is correct.
And the cost for the medical insurance is $580, is that correct?
Yes, ma'am.
Is that just the children's portion or is that everyone?
That's me and my spouse and my kids.
Okay. What would it cost for just your coverage?
So it doesn't, I work federal government, so I got federal insurance. It doesn't change. I can have 7 kids on there or 3 kids. It's the same. So it's,
Is there a cost when it's just you on the insurance?
$80.
Okay. And what's the cost if it was spouse only? Like you and spouse only, no children?
Same as with kids.
Okay. And it's just these 2 children covered, no other children on there?
No, I'm still covering my son too till he's 26.
And that's the son Landon in this order?
Correct. Federal government allows me to cover my children until 26 years of age.
Okay. And for your wife's dental insurance, the cost for that is, where did it go? $156?
A month, yes, ma'am.
Okay. And who all does that cover?
All 3 of my children and me and her, and then her 2 sons.
Okay. 3 children, 2 others, and then, all right. Do you know if it would cost her anything if it was just her on the insurance?
It's like $17.
And does she have a separate spousal only cost? Like her and you just only on there? Would it cost a different amount?
No, our insurances don't work that way. Either you have dependents or you don't.
Okay. And hers is it like yours with the unlimited dependents? Doesn't matter how many you have, same cost?
That's correct, ma'am. She's also employed through same company as me on Fort Cavazos.
Okay. And as far as where you're employed, has your employment changed from the prior order?
As far as what, ma'am?
Are you still working for the same place as you were in the end of 2019?
Oh, yes. Yes, ma'am.
Okay.
Operations Maintenance Division.
Okay. And since then, has your
slightly, a little bit, yes, ma'am.
Would it surprise you to hear that it's doubled?
Well, when I had spoke to the Attorney General Assistant or whoever the coordinator was prior to seeing y'all today, she said that my overtime was being included. Overtime is not guaranteed, nor always offered. I'm currently working the overtime when it's allowed, so that way I can compensate for paying for the medical and paying for child support. It is definitely not guaranteed. So it does look as if my salary doubled, but it's due to me voluntarily trying to stay here and put more work in.
Okay, did that person explain to you that overtime is a part of the wages that we look at for calculating child support?
I see that, but tomorrow my company could say no more overtime the rest of the year. So it's highly inaccurate.
Okay, well, again, sir, I keep having to tell folks that talk to your state legislature because again, they said I have to include overtime. In fact, I'm supposed to look at what you've earned over the last 12 months as some type of indication of what you look at that you would be earning over the next 12 months. It's just what the law requires, sir. Again, there's no guarantee about tomorrow. but the past is carved in stone, so that's the standard, sorry. Anyway, I'll let the state proceed with questioning at this time.
It's fine. I understand I have to share my success.
State may continue. Thank you.
Are you still providing for the children, I guess, their band activities?
There's several things. If asked to pay half on anything, I have no issues. I've been keeping track through Cash App. There's been $1,800 and something extra dollars that I try to distribute to help out with the girls when necessary with band supplies or anything to do with senior year for my daughter, the oldest. I have no issue helping when asked or when it's brought to my attention.
Are you still exercising possession in excess of your normal standard possession order?
Jolynn still comes with me for normal visitation and stuff. Jordan currently works. She works a lot outside of high school. It's been very hard to get to spend time with her because she works almost every weekend. She's more welcome to come out when she has free time, but I think she's a workaholic.
Sounds like her dad. Is there anything else that you'd like the court to consider today, as far as, reasons for deviating?
I would like to try to meet on common ground. 584 extra that I asked her. I said, hey, I get really good insurance at work. I'd really like to take on that responsibility, and that way it would mitigate her cost at work for herself. And we were in agreement that I would take it on in open enrollment in November. I would really like that to be considered. And I know it's saying I make that much money, but at any time that could go down. I get it. That's law, state. I get it. But $1,700 would hurt me really, really bad.
The mother said she said she'll agree to starting the child support at the amount for one child, and that's $1,300 and some change. So,
sir, may I? If I would like to, I mean, it's not a counter, but I don't see why I couldn't pay the $584 in medical cost until they're 26 years old, which is not a requirement by your court, but I'm volunteering to do that, and go from $750, which I'm currently paying, to $1,000 a month, and that would help her out because she's not paying insurance anymore. It would increase her child support, and it wouldn't put me in a hardship at my own home. My wife is currently not employed. She had an injury at work, and we have an entire case going on trying to get Department of Labor to pay her for her workers' comp claim, and it's wrapped up in all kinds of just a disaster right now. So I'm the only income in my house right now.
Yes, sir. I got at I keep saying this to the master math, and right now, the health. I'm sorry. This has been going on a while. The mom's got the health insurance, and dad. Who's responsible for health insurance on this case?
Your Honor, in the prior order, the Miss Miller was ordered to provide health insurance. However, I think perhaps due to out-of-pocket costs, but the fact that Mr. Stiegel has been covering the children, they're asking to switch it to Mr. Stiegel's insurance. And the calculations based on Mr. Stiegel's testimony is that the health insurance for just the two kids is $333.76 per month instead of the $580.66, and the dental credit would be $55.60 based on the same math of subtracting out the spouse plus or the individual person, dividing by the children covered, and then multiplying by 2 since there are 2 children in this case.
And he's been given credit with those amounts against the current child support, correct?
Your Honor, he was ordered to pay in the prior order because Miss Miller was the one that was doing the health insurance. If he was given credit for those amounts, and I believe there's a
Okay. I'm sorry. Stop. Under the current order, the order going forward, who's obligated to pay cover the health insurance?
Miss Miller.
Okay. All right. Sorry. That's why you lost me on that for a second, man. All right, then. Well, then since okay, well, since those are the circumstances, then obviously he's not entitled to the credit based on that, unless there's going to be a change. But I'll let you continue with the testimony. And but right now, as part of the open, I didn't get that we were changing health insurance only to dental, correct?
We were changing health insurance and dental, Your Honor. They were going from Miss Miller to Mr. Stiegel.
Okay, all right. Sorry, I thought you said they were staying with Miss Miller as far as the health insurance is concerned. Okay, I'm sorry. That was my original question. So based on the new amounts, he is getting credit for the health insurance that he now has to cover, correct?
Your Honor, I had to recalculate that based on testimony. I believe his credit was
500 and some change, and now you've done
now
it properly, the pro rata correct share, right? Okay.
yes. So if it were two children in the case, it would be $1,794 in child support, and then one child, if parties were willing to agree to just start it at that amount, is $1,435.
Sorry, what's the first amount again? 1,007? What was the original amount with two children?
1,794.
Okay. And the second amount?
1,435.
That's what the correct pro rata amounts dealing with that. All right. All right, you may proceed with questions. Thank you.
No further questions, Your Honor.
All right, then. I'm going to go ahead and let Dad proceed. The state has recalculated, sir. Again, it appears that they were using the entire amount of cash medical, health insurance payments, and the entire amount dealing with the dental, but it needed to be prorated out based on the number of people that were covered by it, and based on the number of people covered by those insurance packages. The current child support would be $1,784 with two kids in, and when one child remaining, that'd be $1,435 starting the first day of September. And we'll go back to Mom here in a moment to see what she's willing to agree to one way or the other. But again, sir, keep in mind, she does not have to agree to deviation. The guideline supports are what the legislature says I'm supposed to order. And again, unless there's a legal reason for me to deviate, I have to go with what the legislature ordered. Anyway, I'll let you add anything else, sir, you think that you wanted to say as far as what you're requesting the court to do here. And we're going to go back to the mom and get a reconfirmation of what she would like to have done under the standard order amounts for the two different 2 kids in and then one child in. Thank you.
I would just like the court to please acknowledge and consider that I did start paying this in January 1st, 2024. That's when the new plan started for the children. So they are current on it. It's not something I have to enact or ask for here at work. I've already had it taken care of. And it is current since January 1st.
Okay. And I'll have the state re-ask some questions with the mom and see when they and see whether or not when they were taking off her insurance and whether or not that coincides with when you had them put on. Thank you.
Thank you, sir.
All right. Ms. Hubbard, please recall Ms. Miller and get her input on the new amounts and confirmation about the health insurance switching over.
Yes, Your Honor. Ms. Miller, are the children still covered on your insurance through work?
No, ma'am.
When did that coverage end?
January 1st of this year.
Was that because you and Mr. Stiegel agreed for the health insurance to change?
Yes, ma'am.
Okay. So prior to this, he was ordered to pay you $160 each month for medical coverage through your work?
Correct.
And $50 for dental coverage through your work?
Yes.
Okay. And that has been going on since January 1st, you said, correct?
Yes, ma'am.
Okay, so that is a $210 cost each. Your Honor, at this time, I'd like to introduce into evidence State's Exhibit 1, which is a pay record for Mr. Stiegel.
I have a pay record. Let me see if someone has been marked. 5924. Yep, this has got to be it. All right, folks, this is State's Exhibit number 1. This is the financial activity report in your case. It shows what funds have been paid for child support and cash medical through the state disbursement unit in your case. Is there any legal reason, Ms. Miller, they shouldn't come into evidence before the court this time?
No.
Great. Mr. Stiegel, any reason, sir?
No, sir.
All right, State's one's admitted. You may proceed.
Your Honor, the state has calculated at $210 a month that Mr. Stiegel was supposed to pay Ms. Miller for the insurance during the months between January and May, a credit of $1,050. However, there are some arrears in this case that for whatever reason, the withholding from Mr. Stiegel's job was not covering the full amount. So I just posit to the court that those are the amounts we're dealing with.
Ma'am, may I?
Okay, sir, go ahead, please.
I started paying in January the $268 per pay period. So January, February, March, and April, and 4 months worth. So there should be some kind of offset in that.
All right, I'm looking at it there. Well, starting January, there was about the last day of December. It shows, sir, that you were okay. It starts. Looks like it was $528 owed total in both child support and gas medical. That may have just been a rounding error or the money coming in every 2 weeks or some factor like that. But it is what it is. What I need to know is again, ma'am, the state has had to redo the calcs. We apologize for the situation dealing with what we thought the amounts were going to be, but the amounts of credit given were not prorated, were not prorated, ma'am, based on the number of people that were actually on the policy. It was the entire amount. So again, the child support amount is back to my docket sheet. $1,784 for one child, $1,435 starting in September for the other child. What amount are you requesting, or as far as this is concerned, ma'am? And again, you can ask the court to order based on the entire amounts for both kids going forward from the first of the month until it switches over in September. But it's left up to you. It's left up to you what you may want to do one way or the other. Yeah, but you're not mandated to do anything, ma'am. So what are you asking the court to do?
What, with back money? I mean,
No, there's no back money, ma'am.
Yeah, I don't know what you're asking.
Your Honor, there are arrears on this case.
Okay, where am I missing that? Because again,
as of April 30th, there were $23 in arrears on medical support and $196.81 on dental support.
Okay.
I see that because he's paid child support. It comes out of his check. We've not ever had an issue with it. I'm not getting it. So I don't know if that's just the way that they were taking it out or what, but I never thought he was in arrears.
Well, ma'am, again, I can zero those out as of April 30th. That's not a problem. I'll give him credit for some of the things he's done one way or the other based on the what he's been doing extra that's not showing up on that sheet. But while I'm looking at it, it's going forward as far as what the current child support is going to be for both the kids. Again, it's different when the oldest child emancipates in August. It's going to go down, and and before I was telling you, we were telling you it was $1,100 and some change. Well, it looked like it's technically $1,400 in child support starting the 1st of September, and a little bit about $1,400. So what are you requesting the court to do as far as ordering child support in this case, there, ma'am? Full amount, a different amount, what, please?
I mean, I thought we were just going to agree to the one with one child.
Okay, that amount is $1,400, ma'am, and $1,400 what?
$1,435, Your Honor.
All right, I'm taking a recess minute, folks. I need to relook at everything in here because I'm now a little confused too. So anyway, court's don't take a 10-minute break. We're off the record. Thank you.
Thank you.
All right, let's get everybody back on the record on this. Sorry, I had to whip out my calculator. Yeah. All right, we're now back on the record on Coryell County College number DC-16-44,604 in the Steele matter. Anyway, the court wants to go off the record for a moment to relook at the notes again and get this one a little bit back on track. All right, the court, I want to note that originally we were looking at calculations based on some information regarding the father's health insurance costs and dental insurance costs, and that was not prorated. Originally, the court had down the amount for current child support based on the request of the state at $1,707, and I didn't write down the amount for when the oldest child emancipates at the age of 18 and this coming August, but it was $1,300 and some change, $1,300. What was that $1,300 amount, Ms. Hubbard, that you had originally?
1366, Your Honor.
Okay, I got 1360. All right, so it was 1366. Anyway, upon the new calculations based on giving prorating out the health insurance and the medical insurance, the child support amounts should, as ordered based on those calculations, are $1,784 for 2 children, and then
1,794.
94. Sorry, 94. Sorry about that. 94, and when it goes down to 1 child, that's 1,435. Is that correct, Ms. Hubbard?
Yes, Your Honor.
All right. Prior to this, the mother did agree that she would start the child support instead of at the 1,707, would agree to the 1,366, right?
Correct, Your Honor.
All right. But now, like I said, that's gone up about $66, $65, $70. So, all right, now that the medical insurance has been given proper credit, prorating for dad's family and other members on the health insurance and everything, those are the 2 child support amounts we are looking at are $1,794 for 2 children, and then goes down to $1,435 for the 1 child after the oldest child emancipates. So that's the math on this case, folks, 100%. Now, as far as the child support going forward, the father has been paying the health insurance since before it was court ordered, the exchange over. And if I give him credit for that, anything that is owed goes down to 0. So it's wiped out as far as any type of cash medical that is owed, any type of dental that is owed going forward. That would be wiped out with a couple $100 left over on top of that. But the bottom line is, can't go into the negative on that, so only the positive, and it will wipe it out to 0. And so at this time, Mr. Stiegel and Ms. Miller, those are what I'm looking at are the 2 child support amounts and the cash medical amounts. And again, the proper child support amount is the $1,794 and $1,435. Ma'am, based on those, and I'm going to come to you in a moment, sir, based on, originally you said you would live with the 1366. Technically that should have been 1435. Is that the amount you're willing to live with at this time, ma'am, or as far as just going forward with as the oldest child is emancipated, or you wanting the court to do something different, or do you want the court to do include both amounts and just let it fall as per the family code says?
I'm fine to say what we discussed before.
But the 1366 or the 1435, ma'am?
1366.
All right, thank you. All right, then the court, it's not that's a slight deviation downward, not by much, but it is, and it's well within the guidelines for a slight deviation down. And it's we're dealing with less than 3%. So yeah, that's easy. Now, Mr. Steele, that's the math. Mom's still willing to go with the 1366, and that will start the first day of June. We're in May now. And that's about 3% off the guidelines, but again, that's doable in this circumstance. Easy. So again, that's the amount that I'll be looking at order going forward, sir. What else? What would you be asking the court to do under these circumstances, sir?
You were texting while you took a recess, sir, and she was willing to go to 1,200 because I'm covering insurance.
Well, sir, you've already been given credit for that under the Texas under the criteria that the law requires me to give you credit for insurance on, sir.
I'm just telling you the conversation her and I had while you was in recess, sir.
Your Honor, the state's not willing to agree to a deviation.
I know, and y'all really shouldn't have been done that outside the purview of the state. I know y'all can do what you need to do. All right, I'm gonna find, sir, that's not in your child's best interest, and I'm gonna order guideline child support. I get to do this. I get to do these kind of things. So I'll go with the 1366. I'll go with it starting next month, but that's as far as I'm willing to go with, sir. And that's the court's decision. You have the absolute right to appeal me. You have the absolute right to de novo me, but that's what I'm going with at this time. Anything else?
When can I have my next review?
You asked me for legal advice, sir, but technically you could look at these things every 3 years, but every 3 years, sir. All right, is there anything else? I'll start with you, Ms. Miller, again. I'm going to find it's in your child's best interest that I do go ahead and grant the prior amount. it's already a deviation. I understand y'all agreed to some, a few, $166 less, but I'm gonna find that that's not appropriate and in your child's best interest. And as a judge, I can do that. And I'm gonna grant the original deviation of support down to $1,366. I'll go ahead and start that the first day of June instead of the first day of September. That's obviously you were entitled to almost well over $1,000 more during that time frame, but I'm feeling that's a deviation of enough based on these circumstances. And I'll start with you, ma'am. Any other questions? Anything else, please?
No, Your Honor.
All right, Mr. Siegel. Any other questions? Anything else, sir?
No, sir.
Anything else from the state?
Your Honor, do you want to waive court costs?
Oh yeah, I'll wait court costs. The gentleman was up to date on his child support. That's not a problem.
Thank you, Your Honor.
All right, folks, court costs are waived and the modification is granted at the, as ruled upon by the state, by the court as far as child support and cash medical, child support is concerned, and everything else is per the agreement. And we're off the record.
They like their father right now, and I don't know why. I think it's strictly manipulation by my daughter.
Mr. Holder, do you have a relationship with your daughter?
Not much of one, no. It's basically a text here and there.
Have you made derogatory comments to your daughter regarding her same-sex relationship?
I haven't seen my kids in probably 3 years, and I haven't gotten my weekends.
How much do you make per hour?
$40.
Do you work any overtime?
Last year, I got a lot of overtime because most of the plant went down and we had natural disasters.
It's not right for the AG's office to come in my court with these calculations in your lawsuit and just expect me to gloss over them and not look at it.
Dad has to work more overtime hours so he can pay his bills at home.
And it's in the interest of Abigail and Julia Bergstrom.
At this time, the state will call Miss Roberts. Miss Roberts, for your two children that are before the court today, what kind of health insurance do you currently have them on?
They're currently on Oregon Health Plan, OHP.
And is that a plan that you get through the state of Oregon?
It is, yes.
Okay. And what kind of health plan specifically is this?
Like a Medicaid plan?
Do you have any access to any private health insurance that's affordable to you?
My husband just got a job, and so we're switching over to his health plan at least over the course of the next 6 months.
Okay. Do you know what the cost of that health plan would be?
I'm not sure off the top of my head.
Okay. And are you asking the court today to order Mr. Bergstrom to pay child support according to the guidelines based on his current income?
Yes.
Mr. Bergstrom, do you have any other minor biological children that are below the age of 18?
Not biologically. I have my wife's 2 kids that live with us that I'm the sole provider for.
And are you paid hourly there?
Yes, sir.
How much do you make per hour?
$40.
And then do you work any overtime?
Last year, I got a lot of overtime because most of the plant went down and we had natural disasters. But normally, I'm only scheduled to work 42 hours, which is only 2 hours of overtime.
How much overtime do you do on average each week?
It depends on what breaks or whatever's going on in the plant, but most of the time it's usually only about 10 hours.
And are you paid time and a half for overtime pay?
Yes, sir.
Okay. Does your employer offer health insurance that you can enroll your children on?
They do, but it's outrageously overpriced. For just me and my wife, it would only be $200, but for a family of 4 or more people would be over $432 a week.
What were you doing at the time that the previous order was done back on January 20th of 2011?
Working construction, the same job that I do now. I just had a lower rate of pay, which I was a pipe fitter, and that's usually $32 an hour.
I have no further questions. I pass the witness.
Can you hear me, Mr. Bergstrom?
Yes, sir.
All right, Mr. Bergstrom, I read your answer, and what you really wanted to point out in your answer was about your overtime, okay?
Yes, sir.
I have to point out to you, Mr. Bergstrom, that while I understand being in the construction field a long time in my life that overtime is not guaranteed, you are earning it. And as such, your child support has to be calculated on it. Okay? I mean, that's the law of the state. And so if you have a history of earning overtime, Mr. Bergstrom, then I have to use that as part of the calculation. Right now, Ms. Roberts, the children are effectively receiving state Medicaid from the state of Oregon. Is that correct?
Yes, that's correct.
Okay. Ms. Roberts, is there anything else you think I need to know about this case before I make a ruling?
I don't think so.
All right, Mr. Bergstrom, is there anything else that you think I need to know about this case before I make a ruling?
I haven't seen my kids in probably 3 years, and
You understand how the state got to the 1456, correct?
Correct, but that's with a lot of overtime, so that's not my normal pay, and she knows that.
It's the state's understanding that parents are in agreement to have Mr. Knight pay provide health and dental for the child. Medical testimony will show to be cost at zero, and then the dental, Your Honor, the amount just for the child in the case comes out to $95.33 per month. And so guideline support, Your Honor, actually comes out to $14.56. Parties are in disagreement regarding whether that guideline amount should be the order of the court. The proposed order that the court has before it had a $1,200 figure, and that was the result of the parties' agreement. Given the difference, Your Honor, that's clearly not a 10% deviation. Additionally, the parties were in agreement to have contact information disclosed. However, it's something that the state was needing the court to hear about and approve, given the circumstances that led to us pleading for it or having it as an issue in the first place. Who are the children in this case?
It is Kamaya. Well, on the case is Kamaya Knight.
And is it correct, ma'am, that this is the younger of two children you and Mr. Knight have together?
Correct.
But prior orders, ma'am, addressed both of the children. This order would only address the remaining one?
Yes.
And the prior order for the two of you, ma'am, was done back in 2019. Is that correct?
Correct.
And since then, not only have you had one of the children age out, you're also aware of some changes to Mr. Knight's income?
Correct, yes.
As far as the health coverage, was I correct in letting the court know that both of you agreed to having Mr. Knight maintain the health and dental for Kamaya?
Yes.
And then, ma'am, as far as the proposed order, you were aware that the amount submitted in that was the $1,200 figure, correct?
Correct.
And then, ma'am, today, what is it that you're wanting the court to order since you'd previously signed off on that $1,200 amount?
Well, I want the court order to be the amount that was submitted at first because Mr. Knight did not do what he said he was going to do, and therefore it's going to cost me money to do what I need to do for our oldest son that's been aged out.
And when you say first amount submitted, do you mean what was first calculated during a negotiation?
Yes.
Okay, ma'am, but going back just to make sure, the order that the court had before it as non-agreed was for $1,200 a month child support, and you had signed that, correct?
For the agreement that we agreed upon, yes, but not for the amount that was told the first time.
Okay, I'm sorry. Please don't add anything. If my question is a
sorry.
yes, no, or something, answer that, and I'll go into more detail if needed, okay?
Okay.
So the paperwork from the Attorney General's office for today says $1,200, correct?
Correct.
You now want an amount that you're saying was something you had either been told or spoken about, but was not in the paperwork that the court has, correct?
It was, let me see.
Okay, ma'am, real quick, ma'am, but you're asking the court to order the full guideline amount of $1,456. Is that correct?
Correct.
Okay, thank you.
And Ms. Span, you said that the reason for this is Mr. Knight didn't do what he was supposed to do, leading you to need more funds. Is that correct?
Correct.
And these are agreements that you and Mr. Knight made verbally or in writing?
Verbally.
Was there anything else, ma'am, you wanted the court to consider on the issue of the child support amount?
No.
And then, ma'am, as far as the issue of disclosure of addresses, right now, does Mr. Knight already know where you currently live?
He does.
And going forward, are you comfortable updating him if you move from that address?
Yes.
And do you have any concerns, Ms. Spann, about your address appearing in the court's order?
No.
And is it correct, ma'am, that there are no protective orders or criminal convictions between the two of you or anyone else?
No. None of that. No, ma'am.
Was there anything else, Ms. Spann, you wanted the court to consider at this time?
No, ma'am.
Thank you, ma'am. Your Honor, I pass this witness.
All right, thank you very much. We'll be back to you in a moment. Let the state call your next witness.
All right. Thank you.
The state calls Jamar Knight. Sir, what is your full name?
Jamar Antoine Knight.
And sir, is it correct that you have two children with Ms. Spann, but only one of them is still a minor?
That is correct.
And sir, were you able to hear my opening statement that I initially gave the court regarding this case?
Yes, ma'am, I was.
And were you also able to hear Ms. Spann's testimony?
Yes, I was.
And sir, what is your request for the court regarding the child support amount?
The $1,200 that she and I agreed upon.
And sir, as far as the calculations, you understand how the state got to the $1,456, correct?
Correct, but that's with a lot of overtime, so that's not my normal pay. And she knows that.
Mr. Knight, again, let the state say it for you, for Ms. Knight. Just listen to the question and answer the question. And here's the thing, sir, overtime counts. It's right in the family code. I have to consider what you've done in the past is the probability of what's going to happen in the future, sir. Including overtime pay, and next year you don't get it, you can come back and ask the court to change it. But the bottom line is, it's what you actually earn. You know, that cannot be undone, and it's got to be part of the consideration, sir. Sorry.
Yes, sir.
And so, Mr. Knight, as far as the total resources we were looking at, you had a taxable one and non-taxable, correct?
Correct.
And for the employment income, we had the $3,750 as your monthly average. Was that what you were saying included overtime?
Right, that includes overtime. Yes, ma'am.
But that was based on us looking at however long you'd work for the company, at least a year to get that average?
Yes, ma'am.
And then, sir, as far as the medical and dental available for your daughter, those were at the costs that I was letting the court know, correct?
That is correct. Yes, ma'am.
And sir, you do not have any other children besides the one who's still a minor in this case, and of course, your aged out son?
That is correct.
Was there anything else you wanted the court to consider with regard to the child support amount, Mr. Knight?
I just wanted the court to understand that she and I made an agreement, and what she's talking about me doing what I didn't supposed to do, I'm 100% disabled. So my son can go to school for free off of me, and I submitted the paperwork. The paperwork has not came back yet. So since she doesn't have the paperwork in hand, she's saying I didn't do it. And I don't mind paying child support, but I mean, I just want to pay what was already agreed upon. It started off at $1,000. Then she said, no, I want $1,200. Now she's mad at me. So here we are at $1,456. And I don't think that's fair.
Here's the deal, sir. Until it comes, again, I know you folks are not lawyers, but until an agreement comes before the court and both parties say that's their agreement, you don't have a legal agreement, sir. You know, that's if this was $1,400 or $14 million. It has to be agreed to at the time of court, and people change their mind all the time. That's how lawyers get paid. So the bottom line is, sir, the court has to look at the guideline amount as the amount I need to order, unless you have a legal reason for me to do something different, sir.
I do not have a legal reason, no, sir.
Okay. All right, again, sir, and I know it's not completely doesn't seem fair, but you know, until everybody's signatures on the paperwork, including the judges, or at least it's presented to the court as an agreement. It's not technically an agreement, sir. So sorry.
So, sir, when I stop making overtime and then we see the pay is not nearly as much, I can come back, correct?
You can always file a motion to modify, sir. Yes, sir. Because of a substantial change of circumstance. Again, but you need to talk to a lawyer, sir. Again, don't try. Lawyers will tell you whether or not you meet that criteria of getting it changed based on what the circumstances are after another year, sir. Okay.
Okay.
All right. How old is the child in this matter?
Child will be 13.
All right, so there's going to be at least one more modification about the time she's 16, or between 16 and 17, for based on what your circumstances are at that point automatically, sir. somebody else is gonna be sitting in that bench on this bench by then, but well, hopefully somebody else is gonna be sitting on this bench by then. But the bottom line is, sir, there's gonna be at least one more time it's gonna come back automatically, at least should, unless we do another COVID or something like that, So at this time, sir, and I'm gonna go back to you in a second, ma'am. Is there anything else, sir, you want to tell the court? Any other questions you have?
No, sir.
All right, then. Ms. Bongat, any other questions of Mr. Knight at this time?
Yes, Your Honor. Mr. Knight, on the issue of non-disclosure, does Ms. Span already have your current address?
Yes, she does.
Do you have any problems, sir, updating her if you move from there?
No, I do not.
And sir, do you have any concerns about your physical address appearing in the court's order?
No, ma'am.
And sir, are there any protective orders or criminal convictions between the two of you that this court needs to be aware of?
No, ma'am, there are not.
Thank you, Mr. Knight. Your Honor, I pass this witness.
All right, I've been to Mr. Knight. I'll go to you, Ms. Span. You said it's Knight Span. Is there anything else you want to tell the court at this point, ma'am? Anything else you want to ask about? You muted, ma'am.
No, sir, I don't have any other questions.
All right, any other witnesses at this time, Ms. Bongat?
No, Your Honor.
Ms. Bongat, anything in closing, ma'am?
Your Honor, I need to double check the order, but I believe that the state had started the amount as a certain time and taken account of the future pay. Depending on what the court makes its final order, I'd like to go with well, whatever is correct based on the state's records, Your Honor.
All right, then. Well, obviously that'll change a little bit. But again, folks, until there's an agreement before on one of these motions like this, there's not an agreement. The court has to go with the guideline amount. I will not, because of the change, I will not start the new guideline amount, Ms. Bongat, until the 1st of July. So because the change that was in the original order, I will not go back behind that old order. And I'll go ahead and order the follow to maintain the health insurance as agreed. I'll waive court costs due to military service and ask the state to prepare the new order and grant the court to do the state to recalculate based on what the amounts are. But they shouldn't change that much because again, we're going to start the new order on the 1st day of July. So that'll also factor in too. So is there anything else at this time, Ms. Mongat?
No, Your Honor.
Ms. Span, anything else, ma'am?
No, sir.
Mr. Knight, anything else, sir?
No, sir.
All right, good luck to you folks and both your kids, and I'll allow the state to go ahead and prepare the order, circulate it for your review. Again, sign off on it doesn't mean you agree to it. It's just that this is it just means that this is what the court ordered. And again, the court went straight down the line as far as what the family code says I'm supposed to do at this point. Anyway, like I say, good luck to both of you and your children, and everybody have a safe summer, and we're off the record. Thank you.
How much do you make per hour?
$40.
Do you work any overtime?
Last year, I got a lot of overtime because most of the plant went down and we had natural disasters. But normally, I'm only scheduled to work 42 hours, which is only 2 hours of overtime. I'm now going to have to up my amount of hours I work a week to about 60 to where I can actually cover that and my actual bills I have at home now.
I haven't seen my daughter for the whole year. I haven't seen her once.
At minimum, he works a 20-hour a week overtime at minimum. We constantly stayed in conflict about it. So him introducing that he's standardly, and this has just changed in the past 6 months, I know it's not true.
Just stated that you have this information that you testified to regarding the father's wages. How do you have that information if you are not in a relationship together?
This is a paternity action. The concept of paternity is very important as the father of a child has certain rights and responsibilities towards that child.
Your Honor, this is a paternity action. We have some agreements. The disagreements are mostly around support. The agreements are joint managing conservatorship and establishing paternity for the child or children. In this case, a standard possession order, neither party requests a finding of family violence or the need for a non-disclosure to be ordered. Parties agreed to a residency restriction to Dallas and surrounding counties. Parties stipulate that the father, in this case, a non-custodial parent, has two other children, one that lives with him and another child that he pays child support on. I now call the mother. Ma'am, can you state your name for the record?
Crystal Williams.
And ma'am, do you have any information regarding the father's income?
I do. So
let me just get to my next question.
Okay.
Before I do that, how are your children covered through insurance?
State benefit.
Okay. Do you have any private insurance available for them?
Not at the moment, no.
Okay. And what information do you have regarding the father's income?
So he has worked at the same employer at minimum the past 5 years. And in our 3 years of in our relationship, at minimum, he works a 20-hour a week overtime at minimum. His standard shift is from Saturday to Monday. We constantly stayed in conflict about it. The reason he didn't want to do it is because of the overtime availability for the rest of the week. So him introducing that he's standardly, and this has just changed in the past 6 months, I know it's not true.
All right, ma'am. And you understand that the state is going to ask for a ruling based on his income, that we are not taking a position, either your side or the father's side, regarding income, that we're going to ask the judge for a ruling, correct?
I understand.
Okay. So based on the information that you have provided and testified to, the state did a calculation and calculated child support at $679. Is it your wish for child support to be ordered at that amount?
I would agree to that, as we were already in a agreement of him paying $150 a week up until about February of this year.
Okay, ma'am. And based on that, on what you're proposed, the information that you have provided, the state had done a preliminary calculation of $160 for cash medical. Is it your wish that that be ordered?
I mean, I'm okay if he wants to provide her medical. So I'm okay either way that goes.
Okay. And based on the information you provided, the state did a preliminary calculation of retroactive support at $6,111 to be paid out at $81 a month. Is that your wish for that to be ordered?
Yes.
And ma'am, I hear that you just stated that you have this information that you testified to regarding the father's wages. How do you have that information if you are not in a relationship together?
Is anyone else see that she's frozen? What's happening?
Ms. Williams, did you hear that question?
So I wasn't sure if it was me or her. So all I heard her say was, "It's my understanding based on your testimony," and I don't know what else she said.
Okay, I think
okay.
Go ahead.
I'll repeat the question. I think it is your side that's breaking up a little. Okay. So how do you know about his income?
Again, so we were in a relationship for 3 years. The same employer he had prior to us dating, and the one he's at now. And that has been his consistent schedule and routine throughout our tenure. That was also his schedule and routine prior to us dating, based off of the information he provided to me. I'm also aware that peak season typically happens for his organization starting at or around September, and it usually doesn't go down until about March or April of the following year.
Okay. Have you seen any of his pay stubs or anything like that within the last month or two?
No, ma'am.
Okay. Could it be possible that maybe his workflow changed?
No, ma'am.
Okay. Anything else you would like to tell the judge?
Not at this moment.
Okay. I pass this witness and I call the father. Sir, can you state your name for the record?
They call it mango. I have some concern though.
Sir,
Yes.
listen to my question.
I didn't
Yes, ma'am.
understand what he said. Sir, can you repeat what you just said?
I said I have some concern.
What's your concern, sir?
We've been separated for almost a year now, and I always take care of my daughter.
Okay,
And
let me
and
just stop
I
you right
I
there,
have
sir.
here
Stop, Mr. Mango.
I have here an
Stop.
insurance. Okay, sorry.
Sir, I understand that you are contesting some issues. I understand that you are contesting some support issues. We will get to those issues in just a moment, I promise.
Okay.
The question that I'm asking you is, are you in agreement to joint managing conservatorship and to a standard possession order?
Yes.
My next question, are you in agreement to a geographic restriction to Dallas and surrounding counties?
No.
Sir, do you understand that a geographic restriction means that the mother would be required to keep the children in Dallas and surrounding counties? Do you understand that?
Oh, I didn't know.
Okay, now let me ask you, what do you do for a living?
I work at warehouse. I'm a sanitation.
Okay, and how much do you earn per hour?
22.40 something.
Okay, and how many hours do you work per week?
36 hours.
Okay.
And sometimes it depends how things goes. I go in. So for either 2 days or 3 days. But right now I haven't been in. I haven't have no more overtime because right now there is a big change in my company.
Okay, let's talk about overtime. In the
Yes.
last 12 months, have you worked any overtime beyond the 36 hours that you just
Yes.
stated?
Yes, ma'am.
If you had to look at the last 3 months, how many hours per month, how many overtime hours have you done in the last couple of months?
If this month, no overtime.
Okay, last month.
Yeah, this month, no overtime. Last month, I can say max 10 hours, 15 hours. Because like I said, we just have a big change in my company.
Okay, the month before that.
And the month before that, I was working maybe 10 hours, 12 hours overtime.
Okay. The month before that.
No, really. I don't.
Okay, and the month before that.
No.
Okay. All right. Sir, how is your child currently covered through medical insurance?
Okay, my child has been since she was born. No, with through Cigna from my company. All of my kids are with my company, and I even sent her a copy of the card, and I have to renew that tomorrow.
Okay. How much does it cost to carry your children?
I don't know. I think I have the family package, and I have that with me, but it's somewhere in my car right there. I don't have that on my hand right now, but it's around 98 for the family package.
$98 per month, per week?
Per week.
How many people are on that, or which people are on that plan?
3 of my kid plus my stepdaughter.
Is a child or children in this case on that medical plan?
Yes.
Does the $98 a week include you?
Yes.
The state calculated child support at $450 if the judge orders you to carry the medical insurance. Are you in agreement with that judgment, with that obligation?
Yes.
And you understand that unlike the amount that I previously read, which was the 679. This calculation includes no overtime.
Okay.
Okay. Do you have anything additional you would like to offer to the court?
Yes. Okay. I haven't seen my daughter for the whole year. I haven't seen her once. I've tried to talk to the mom, trying to reach out to her, but she said until she feel like she okay with it and I can see my daughter. And that bothers me.
Okay. I pass this witness.
All right, I'm making a finding that the parties be joint managing conservators that were establishing that you're the father of this child, Mr. Mango. We're doing a standard visitation order, which is the first, third, and fifth weekends of each month, from Friday at 6 until Sunday at 6. Each of you are to give each other's addresses now and any time in the future. Mr. Mango would appear at your residence, Ms. Williams, for the pickup on those Fridays at 6, and bring the child back to your residence on Sunday at 6. If you don't appear, then you don't get visitation. If y'all want to work out some other schedule that works for both of you, we definitely can do that. The child definitely needs to be with her father. So if maybe it's a deal where Mr. Mango doesn't get off of work in time, I would expect that y'all would reasonably work out some kind of settlement as to a different time frame that's a stable time frame, so that we understand what needs to happen to have visitation start. Make it a finding that there's been no family violence. As far as health insurance concerned, Mr. Mango, you need to provide Ms. Williams a copy of the insurance card. I'm going to order that you primarily are responsible for carrying the health insurance. If you don't, then you're going to be responsible for 100% of all costs.
Yes, sir.
If Ms. Williams doesn't receive a copy of the health insurance, she may continue to use the Medicaid or CHIPS, and then the child support office may bring y'all back to court again to modify this order. So it's very important that Ms. Williams gets a copy of the insurance card within 30 days of today's hearing, preferably today, because the child needs to have that if Ms. Williams needs to take the child to the doctor for whatever reason.
Yes, sir.
I'm not going to order, please don't talk while I'm talking. I'm not going to order you to pay any medical support. So the $160 that they requested, I'm not ordering that, since you're going to be paying for the health insurance premium. And I guesstimated your cost somewhere around $200 a month, because half of it is for your insurance and half of it is for the child. I calculated on my own independently of what everybody else calculated, that I think what was appropriate is to do child support based on 40-hour week plus 10 hours. Because sometimes you may work 20, you may work 15. I'm not trying to set it at the highest amount, but I don't think it's appropriate to do it at 36 hours. Based on my calculation, I got almost the same number independently of what the Attorney General's office calculated. The child support should be $678 a month based on that calculation. I don't think it's perhaps the last week or two you haven't done 40 hours, but I need to look at it over a whole year to kind of know what's a better calculation. And you didn't provide any information other than what you've told us. And if there's some times where you work 20 hours, that's great. And then there may be times where you don't work 40. I'm trying to find a number that's in the middle that will balance out. So that's why I did it at 10 hours of overtime per paycheck. Okay. So the retroactive judgment is $6,111, payable at $81 a month. The Attorney General's office will draft an order based on my ruling today, email you both a copy, and then they'll send out a withholding order to take it out of your check. You are done with court. You can press leave on the Zoom to exit out. Thank you.